Ladies and gentlemen, may I have your attention, please? Honorable guests, ladies and gentlemen, may I please have your attention for a moment? May I request you to kindly take your seats because we will be starting our next session in about 5 minutes' time or less. The guests have already made their way into the hall. May I please request you to take your seats? Kindly take your seats. May I request the usherers to please ask the people who are in the hallways outside to come back and take their seats? Please. The usherers, if I could please request you to have the people who are standing in the hallways to come back into the hall and take their seats, please.
दोस्तों आप लोग बैठ जाए प्लीज हैदर भाई सर प्लीज हैव अ सीट इनको बोले बैठ जाए
Councils who are standing in the hall, in the aisles, can you kindly take a seat or have others take the seat, please?
दो तीन मिनट बाद बुलाते हैं
हाँ जी 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 जी
एक्चुअली लोग नमाज पढ़ रहे हैं
जी जी
पहले खाना खा रहे थे नमाज पढ़ रहे थे
The most inefficient aspect of our society is human beings. Systems work just fine. It's people. Even amidst the pleasantries, may I please request you to take your seats? The usherers in the middle aisle over here, can you get people to sit down, please? Your Lordships, our usherers are compelled by limitations of the profession to force everybody to sit down. So can you kindly please take a seat? At the back, please, those in the aisles, can you kindly take a seat so we can commence the next session?
तो जैसा आपको आप बताएंगे ना। चल ठीक है।
Go, please. Please take your seats. Our international participants for this, may I have your attention, everyone? Please take your seats. The international participants for this next panel have already joined us. Honorable guests, ladies and gentlemen, giving Haider Wahid Saab a little bit of a break in the middle, I am once again entrusted with the responsibility of introducing this next panel. The next topic, as you've seen since morning, that a number of varied issues, all of which are important and connected to our legal paradigm, have been discussed by the worthy participants. The next session is of, in many ways, even more of an importance to both our judicial enterprise, our legal enterprise, as well as the overall well-being of the country. While making this, may I once again request those who are standing in the aisles to please take your seats. We've already been joined by the international participants for this next session, and we don't want to keep them waiting for too long. This next session will speak about and discuss a number of ideas that relate to the economics of the law, to the way we do dispute resolutions through various arbitration mechanisms, how we provide, or what are the mechanisms through which we can provide security to investors in Pakistan, how do we protect capital and ensure that intellect as well as capital in this country is looked after not through the might of any state institution, but instead through the protection of our laws and the strength of our laws. In this perspective, the next session, which deals with economic challenges and dispute settlement mechanism, as well as the legislative reform and a roadmap for the future. May I please, with your welcome, please welcome Mr. Justice Ijazul Ehsan Honorable Judge of the Supreme Court of Pakistan, to preside over this next session. Your Lordship. Joining Honorable Justice Ijazul Ehsan will be an expert in global development and framework approach to alternative dispute resolution, Mr. Justice Abha Nayyar Patel. He's a fellow of the UK arbitration panel. He'll be joining us over Zoom. Along with him, also joining us electronically through Zoom, is Mr. Ravi Mandasame. He's an advocate of ESG compliance and regulations based out of Singapore, and he'll be focusing his talk. He's an expert in compliance of environment, social, and governance standards for investor confidence. Also joining us and in person, and we thank her a great deal for her joining us in person, is Ms. Leonardo Riesenberg. She's an international arbitrator based out of Dubai, and she is an expert in the regional and global economic trade and investment challenges. May I please welcome you, ma'am, to the stage. Thank you for joining us in person, and we hope that you had a wonderful conference and stay here in Pakistan. Alongside Ms. Reisenberg, we also have Mia Shiraz Javed Sahab, Chairman of the Pakistan Chapter for Arbitration. He also is an expert in protecting and structuring economic zones across Pakistan, and in particular with the growth of CPEC in Pakistan, he's the right expert for the dispute resolution mechanisms. May I please welcome Mia Shiraz Javed Sahab to the stage. And last, but certainly not the least, Mr. Justice Honorable Jawad Hassan Sahab of the Honorable Lahore High Court. Justice Jawad Hassan has authored some of the absolutely groundbreaking judgments in terms of commercial law, corporate law, banking law in Pakistan. Even today, away from corporate and banking law, when you heard the Women's Right Forum and the Women's Right Panel earlier today, even that quoted a judgment from Honorable Justice Jawad Hassan. Welcome to all the panelists, and Your Lordship, over to you, please. Yes.
Good afternoon, you all. I hope everybody enjoyed the lunch and are awake enough to go through this session, but I promise it is going to be a very interesting session. Honorable Chief Justice of Pakistan, Mr. Justice Umar Ata Bandial, Honorable Judges of the Supreme Court, the Honorable Acting Chief Justice, Federal Shariat Court, the Honorable Chief Justice, Supreme Court of Azad Jammu and Kashmir, Honorable Chief Justices and Judges of the High Courts, the Honorable Chief Justice of the Supreme Appellate Court of Gilgit-Baltistan, Your Excellencies, the ambassadors of various friendly countries who have taken the time out to attend this conference on our invitation, thank you very much. Learned members of the bar, which I see in large numbers, which is very encouraging. Distinguished guests, panelists, ladies and gentlemen, good afternoon. First of all, I would like to congratulate the Conference Committee of the Supreme Court of Pakistan, the Law and Justice Commission of Pakistan, the Secretary of the Commission, and their entire team of youngsters for organizing this wonderful conference. I can see your hard work has paid off. You have done a great job. Well done. The topic for this session of the 9th International Judicial Conference is Economic Challenges and Dispute Settlement Mechanisms, Legislative Response and the Roadmap for the Future. Justice Sandra Day O'Connor of the U.S. Supreme Court wrote as far back as 1980, "The courts of this country should not be places where resolution of disputes begins. They should be places where the disputes end, after alternative methods of dispute resolution have been considered and tried." Disputes are an unavoidable reality of the society and have existed since time immemorial. Disagreements can be unpleasant, even offensive, but they are vital to human reasoning. This is because they generate debate, which is essential to prevent stagnation in the society. Many a progress in civilizations is an outcome of effective resolution of disputes. Understanding disagreement with an open mind gives one a glimpse of the other end of the spectrum. However, excessive and unresolved disputes can harm the smooth working and functionings of the state in the shape of political, social, and economic challenges. It is therefore essential for a country to have an effective dispute resolution mechanism in place. This is especially so because while developed nations have the necessary fiscal muscle to cope with economic challenges, developing nations are only left with options to manage disputes inexpensively and often informally. As such, the importance of alternate dispute resolution, ADR for short, cannot be overstated and is a need of the hour. ADR methods have continuously evolved over the years to meet the ends of modern disputes and provide creative, inexpensive, and expeditious outcomes. ADR is an authentic paradigm shift in the way disputes are handled beyond the traditional court system. A variety of ADR methods exist today which provide effective solution in simple and complex disputes. In an economically tumultuous environment, alternative methods of dispute resolution such as arbitration, mediation, negotiation, and conciliation provide business entities and citizens with an option to settle disputes without going through the arduous and expensive process of litigation. In economically challenging times, litigation does not seem to be a viable option, especially to resolve commercial disputes. Businesses must remain afloat so that they can contribute towards the smooth functionings of the economy. Prolonged litigation can prove to be a stumbling block. As such, arbitration and mediation ought to be promoted for effective methods of resolution of commercial disputes. Most commercial entities prefer to resolve disputes by referring them to arbitration. This is primarily because the binding nature of an arbitral award provides certainty to the parties. While it may be tempting to go in depth about how arbitration is carried out internationally or how an arbitrator is supposed to act in certain situations, I think it would be more prudent to talk about arbitration matters in the context of Pakistan. For instance, How important is the adoption of arbitration as a mechanism for alternate dispute resolution in Pakistan? Is there a sufficiently reasonable legal framework in place that will facilitate arbitration? And most importantly, how would Pakistan's judiciary benefit if arbitration becomes the go-to method for dispute resolution? Historically, ADR has never been a concept alien to Pakistan. Cultural specific methods akin to arbitration, such as referring disputes to jirgas and panchayats, have existed in the subcontinent since time immemorial. While one can argue that there was no parity or party autonomy in the jirga or panchayat, since one could not question the decisions given by jirgas and panchayats, it is nonetheless important to note that there is a history of alternative dispute resolution in Pakistan, which means that it would not be difficult to adopt alternate methodologies for dispute resolution. For arbitration to be effective in commercial disputes, a robust legal framework is necessary. The implementation of an arbitration award is often dependent on the ability of the local courts to recognize the arbitral award in question and whether or not a court has the jurisdiction to implement the arbitration award. In Pakistan, the Lex Loci Arbitri is the Arbitration Act of 1940 and the Recognition and Enforcement Arbitration Agreements and Foreign Arbitral Awards Act 2011. The 2011 Act was legislated by virtue of the fact that Pakistan is a signatory to the 1958 UN Convention on Recognition and Enforcement of Foreign Arbitral Awards, more commonly referred to as the New York Convention. Most foreign arbitral awards that parties seek implementation of in Pakistan come from the ICC Court of Arbitration, the London Court of International Arbitration, the Dubai International Arbitration Center, the Hong Kong Arbitration Center, and the Singapore International Arbitration Center. The process of arbitration is fairly flexible and informal, as we all know. However, the flexibility and informality is lost when the implementation process is regulated as if it was a regular suit and subject to all procedural laws that regulate execution of decrees in our country. This is especially important in light of the fact that in most scenarios, the parties to an international arbitration award use local laws when it comes to the recognition and enforcement of arbitration agreements and arbitral awards, even where the arbitration itself was regulated by another set of rules. Unless Pakistan's laws are brought into the 21st century, it is difficult for the courts in Pakistan to operate in a vacuum. The courts are here to oil the wheels of commerce and not to put a spanner in the works or even grit in the oil. The Supreme Court of Pakistan's recent pronouncement in the case of Orient versus Sui Northern Gas Pipelines Limited, reported as 2021 Supreme Court Monthly Review 1728, has, without a doubt, brought the judicial interpretation of Pakistan into the 21st century, at least in terms of interpretation of the Lex Loci Arbitri. It was held by this court. The jurisdiction of courts under international commercial arbitration is merely supervisory. We deem it necessary to step in under circumstances only where, if we are made aware that the arbitration award or the agreement would lead to unfair outcome for one of the parties. This in no way means that domestic awards would be treated less favorably than foreign awards, but rather the aim to create a level playing field between the two and treat them at par. This interpretation of the Supreme Court has shown that Pakistan has the ingredients required to have a commercially conducive, arbitration-friendly legal framework when it comes to the jurisprudence laid down by the Supreme Court of Pakistan. An arbitration-friendly environment is essentially required in Pakistan to attract and retain foreign direct investment, such as the China-Pakistan Economic Corridor, foreign investment in the power, heavy industry, and infrastructure projects, which attract significant foreign investment. The existence of an arbitration-friendly environment ensures the smooth operation of such ventures. Investors are given the certainty of the fact that arbitration clauses in commercial agreements would be honored and disputes would be resolved expeditiously, which in turn prevents investors from being dissuaded and allows the free market to flourish. ADR, ladies and gentlemen, can be an effective mode also to reduce caseload and backlogs in courts. Presently, there are about 400,000 cases pending in the high courts of Pakistan and around 1 million civil cases pending in civil courts all over Pakistan. ADR would, in my opinion, reduce the current workload on the judicial system. At least it has the potential to do that. In civil cases, mediation and conciliation can prove to be an effective and efficacious remedy in expeditious disposal of disputes. These methods provide parties with privacy and can help parties preserve their relationship. The legal and procedural intricacies which courts are required to follow can sometimes be an obstacle in the way of quick and effective dispute resolution. In sensitive matters, mediation and conciliation offer confidentiality when compared to the conventional court system, where matters become part of public record. Out of cases pending before courts, many are of a personal nature, which do not necessarily require adjudication by a court of law. However, due to a general lack of awareness regarding ADR methods, litigants are forced by default to go to courts. While recognizing the eminent need for ADR, Pakistan has recently introduced various laws. Examples of such legislation, amongst others, are the Khyber Pakhtunkhwa ADR Act 2020, Punjab and Sindh ADR Acts of 2019 respectively, and the Islamabad ADR Act 2017. Under these laws, both civil, and this is important, compoundable criminal offenses can also be referred to ADR. I don't think there are many jurisdictions criminal matters can also be referred to ADR, but there is this additional feature in our laws that in compoundable offenses, matters can also be referred to ADR. Further, Section 89A of the Civil Procedure Code allows courts in Pakistan to refer matters to arbitration if the litigating parties consent to resolve their disputes through ADR. A way forward for adoption of ADR would be to empower the courts to determine the suitability of whether a matter should be referred to ADR and encourage parties to adopt this route. This would allow the courts to facilitate ADR in suitable matters, but at the same time, not shutting the parties out of the court system should ADR not succeed. The possibility of such eventualities should not overshadow the benefit that the judicial system would derive by adoption and encouragement of ADR. Backlogs of cases would fall, matters would be resolved in months, if not days, drastically reducing both the time and money spent on litigation. The reduction of cases would also allow the courts to hear contentious and complicated matters. The economic benefit that the country would derive from an efficient use of ADR by the judicial system should no doubt be a boon to the legal system as well as the litigants. ADR centers in this context, we would encourage that they be established. Citizen awareness drives must be carried out so that litigants are apprised of the benefits of ADR. Training of mediators, arbitrators, and negotiators must be undertaken so that necessary manpower and expertise is available. Necessary amendments must be made in the laws to ensure that the overriding objective of providing inexpensive justice is met. Colonial laws must be modernized so that they are brought in line with our international obligations to promote ADR. Lastly, the legal fraternity must also play its part in discouraging frivolous claims and encouraging referral of matters to ADR for resolution of relatively simple disputes. Lawyers must play their part in advising parties to settle matters through ADR rather than wasting time and resources on frivolous and long-drawn litigation. Before I conclude, I would like, on a lighter note, to show why one should prefer ADR as opposed to litigation. Fans of Charles Dickens and lawyers alike will, no doubt, be aware of one of his finest works, Bleak House. The central theme of the book revolves around the Jarndyce family and perpetual litigation that embroils the family for generations to come. Dickens wrote, "Jarndyce and Jarndyce drones on. The scarecrow of the suit has, of course, in time become so complicated that no man alive knows what it means. The parties to it understand it the least. Scores of persons have deliriously found themselves made parties in Jarndyce and Jarndyce without knowing how and why. Whole families have inherited legendary hatred with the suit, but Jarndyce and Jarndyce still drags on with its dreary length before the court, perennially hapless." While Dickens wrote Bleak House in 1850s, the message is clear. We have not learned our lessons. To ensure justice between the parties, in my opinion, ADR could be one of the options and a very viable option. Jarndyce and Jarndyce may be fiction, but with ADR, it will remain fiction, will go back to fiction for times to come. In my view, ADR is, without a doubt, a feasible and effective option that policymakers, lawmakers, the judiciary, and the litigants must encourage, adopt, and promote. I thank you all for attending this conference. We are honored and privileged to have you all. I hope you have enjoyed all sessions. There is one more session to go. And I hope that you will benefit from the thoughts and experiences shared here today and yesterday by eminent and illustrious speakers and panelists in the conference. Thank you very much.
Thank you very much, Your Lordship. While, as my Lord has already pointed out, that the alternative dispute resolution mechanisms and informal ways of in an efficient and timely and cost-efficient manner resolve disputes is a critical part of what Pakistan endeavors to do. But we have much to learn still from the international experience of other countries. One such expert who can teach us a great deal about what the best practices are and how we can learn from them is Mrs. Justice Abha Nayyar Patel, who's joining us via Zoom today. And her topic will be global developments in legal framework approach in the alternative dispute resolution mechanisms. Madam Justice Abha Nayyar Patel, please. There is some problem with the sound. Madam, just a moment. We're trying to fix a problem with the sound.
Thank you.
We can hear you now. The floor is yours.
Thank you very much. The Honorable the Chief Justice of Pakistan, Honorable Chief Justices, Honorable Judges of the Superior Courts, all government, diplomatic and judicial officers present, allow me to ride on the protocols eloquently established by the Honorable Chief Justice of Pakistan when he delivered his keynote address yesterday, and refer to you all simply as distinguished conference participants, ladies and gentlemen. Good morning from sunny Zambia, and good afternoon to you all in Islamabad. It is my singular pleasure and delight to have been invited to share a few thoughts on this session, Global Developments and Legal Framework in Alternative Development Dispute Resolution. And I will speak with specific reference to Zambia. Let me also convey at the onset the warm greetings from the Chief Justice of the Republic of Zambia, Honorable Dr. Justice Mumba Malila, State Counsel, to you, Honorable Chief Justice of Pakistan, and to this very eminent gathering. I'm grateful to Mian Shiraz and his team for their efforts and kind invitation to facilitate at the forthcoming training for mediators in Pakistan. And though I was regrettably not able to travel, I'm delighted that I was able to meet you all and speak to this subject, which is very dear to my heart, albeit virtually, at this very important judicial conference under the theme, Administration of Justice, 75 years, reflecting on the past and looking towards the future. Thank you also to the session chair, Honorable Justice Ijaz ul Hassan, Judge of the Supreme Court of Pakistan, for your warm welcome and for your very, very remarkable introductory comments. I'm equally pleased to meet my co-panelists. Honorable Session Chair, your opening comments have in fact touched on topics that we are speaking to today. And it is comforting to hear that we all seek the same reforms and robust judicial activism. Without further ado, let me speak to my paper in the knowledge that the same has been circulated, and I'm available to answer any questions that may arise in plenary. Let me also state that I'm excited to hear and learn from other experiences that we hope to share today, as I believe judiciaries around the world, and Zambia is no exception, are struggling with a perennial problem of backlog of civil matters and over-congested court dockets. Let me speak to development of alternative dispute resolution in Zambia. The importance of this topic, both in terms of access to justice and decongesting backlog, cannot be overemphasized. There is, in fact, an overriding public policy element to this debate. This initial project in Zambia was spearheaded in 1997 by the Zambian judiciary with the assistance then of the United States Agency for International Development, the USAID. This was in keeping with the policies of promoting good governance, access to justice, and for a speedy and effective resolution of matters, especially of a commercial nature. This led to the law reforms of 1997 by the promulgation of Statutory Instrument Number 71 of 1997, which had the effect of amending Order 31, Rule 4 of the Rules of the High Court, Chapter 27 of the Laws of Zambia. This was the first time in Zambia where reference was made to court-annexed mediation by the referral of matters that were suited for mediation. And this, over the years, has become a subject of intense debate by their lordships and ladyships. The classical form of mediation that has been taught and used for decades in such area as family law and community dispute resolution matters, is still central to the approach taken by most mediators. Many of the steps and techniques involved, such as having the parties begin by each stating their problem, allowing for ventilation of feelings and emotions, and encouraging joint problem solving, are applicable to all forms of mediation. You are all aware that the essential ingredients of classical mediation, to touch on just a few, are its voluntariness, the mediator's neutrality, the outcome of the process being in the hands of the disputants. Procedures are largely informal and flexible. Privacy of the matters remains intact. Costs of litigation are reduced. Less time is required than other means of resolving disputes. Generally, parties leave satisfied with a win-win solution. From then to date, we have made strides in the advancement of formal ADR processes, and mediation, and indeed arbitration, have a firm place in our legal system with the support and blessings of the judiciary. The new Arbitration Act number 19 of 2000 repealed and replaced the old Arbitration Act number 3 of 1933. In my paper, and as invited so to do, I will restrict my comments on the development of mediation in Zambia from 1997 to the present day. The enactment of the Constitution, the Amendment Act number 2 of 2016, enjoins the judiciary to promote ADR mechanisms. Article 118 refers. Statutory Instrument number 27 of 2012 saw further amendments to the High Court rules for the referral to mediation to be at the stage of scheduling conference and to reduce the number of days for the conduct of the mediation. This was obviously to deal with the public outcry of costs having escalated if the matter is referred very late in the litigation conundrum. For the first time, parties that refused or failed to attend the mediation could be condemned in costs. It is cardinal to note that attendance is necessary, but a resulting settlement is obviously voluntary. The Supreme Court of Zambia had the opportunity to strike out an earlier rule on the ground that it offended the basic bedrock of the voluntary nature of mediation in its decision in a 2006 case of the Bank of Zambia versus Nyambe. Further amendments to the rules of the High Court by way of Statutory Instrument number 72 of 2018 ushered in a mere mandatory referral of all cases to mediation before settling the matter down for trial. The obvious exceptions, of course, are matters involving constitutional issues, liberty of an individual, or urgent matters such as injunctions and generally other matters which, in the discretion of the judge, are not amenable to mediation. The statutory instrument is very detailed and gives wide guidelines for the conduct of the mediation, and especially allows parties to choose a mediator of their choice from a list of quarter-next mediators, in keeping with the philosophy of mediation being a party-driven process. It also speaks to costs deemed thrown away for failure to attend mediation, irrespective of the final outcome of the matter in court. It also calls for specific functions to be discharged by the mediation office. Another decision of the Supreme Court of Zambia has recently had the effect of settling the position of finality of a mediation settled by agreement, whereby the court has confirmed that the settlement agreement, once registered with the court, is final and binding on the parties and may not be the subject of an appeal, review, or any other process, save only for enforcement proceedings. This was the case of Charles Mambwe and others versus Mulungushi Investments in Liquidation. It's a 2016 decision of the Supreme Court. Between 1999 and 2002, the judiciary embarked on an aggressive training in mediators to form a pool of multidisciplinary trained mediators. This was again done through the assistance of the USAID, when the first set of mediators and trainers in mediation were trained. I was one of those that was trained in mediation and subsequently became a trainer of mediators. From 2002 to date, I have been involved in training and subsequently enlarging the pool of quarter-next mediators. Simultaneous to the training of mediators, the judiciary was engaged in sensitization workshops for legal practitioners, members of the public, and other stakeholders. This took the shape and form of training workshops, radio and television broadcasts, as well as holding mediation settlement weeks as part of the gazetted court calendar. The judiciary, though having seen great improvements in the practice of mediation, has, since in or about 2020, embarked on new and more focused areas of training of mediators. These include, inter alia, refreshing training of the existing mediators, training of a new pool of mediators, training honorable judges on matters best suited for referral to mediation, best practices in the world of mediation, including the advent of the virtual mediation on various virtual and digital platforms following the pandemic of COVID-19. In Zambia, we have seen the usual resistance from the legal fraternity, who see ADR as an acronym for a drastic loss in revenue. These are constant struggles between an overworked judiciary and the worldwide challenge of backlog of cases. This is a universal issue and not new to Zambia alone. In a world where people are more and more litigious and access to justice remains a preserve of the few, constant change and dialogue to foster, promote, and enhance the use of all forms of ADR is a daily mantra in the quest for universal justice. Zambia, and I dare say Pakistan, is no exception. Zambia is currently working on its draft code of conduct for mediators, which code has not been finalized, and there is dire need for its conclusion to settle issues on ethics, continuing education, and other areas of concern. There are also calls for Zambia to ratify and domesticate into law the Singapore Convention on Mediation. We can compare this to the strides that Zambia has made in the field of arbitration, both domestic and international. We have seen the enactment of the the court proceeding rules of 2001, and the arbitration code of conduct and standards, the regulations of 2007, introduced in Zambia in 2001 and 2007, respectively. There have been learnings made both by the bar and the bench in this 25-year journey from 1997 to date. We have the usual infrastructure challenges that besiege most judiciaries in the world: lack of adequate mediation rooms, lack of training of mediation officers and clerks, lack of prompt and efficient follow-up of records to ensure that they do not fall through the gaps and become yet another nightmare of backlog in the judiciary's quest to deal with that backlog. I have recently had occasion to read the comments of Judge Stephen Wildblood in a 2020 decision in England, where the judge, in not mincing his words, criticized the parties and their lawyers for clogging up the already overfilled family courts with unnecessary, high-conflict private litigation. He considered these an inappropriate use of limited national court resources. The message should be a clear and unequivocal one from national judiciaries. Do not bring your private law litigation to the family courts unless it is genuinely necessary. Settle your differences away from the courts using ADR routes such as mediation. In England again, from whom we have inherited so much of our procedural and substantive law, it is noted that too many divorce cases were ending up in court, more especially following the introduction of a no-fault divorce in April this year, with warring couples viewing the courts as their first rather than last port of call, mistakenly believing that they have legal rather than relationship issues. Since 2014, it is a legal requirement to attend an initial mediation information and assessment meeting, known as the MIAM, before issuing a court application to resolve a family dispute. It is argued by the lawyers, however, that many judges are not robust enough in enforcing this, and the requirement has become a box-ticking exercise honored more in its breach than in observance. Session Chair and fellow panelists, I conclude with the full realization that the judiciary cannot deal with this alone. It can essentially only train its judges and staff to be supportive and complement the efforts made by the wider stakeholder participation. There has to be stakeholder buy-in at a bigger and perhaps national and international level. This is where bodies such as the Chartered Institute of Arbitrators, through their national branches, need to step in and fill the gap by training and creating an enlarged pool of ADR practitioners, be they arbitrators, mediators, construction adjudicators, and the like. I have also learned with delight that the Pakistan branch of the Chartered Institute of Arbitrators will be conducting its first ever training in Module 1, Mediation, which relates to commercial mediation. I submit that there is growing need for the development of commercial and court-annexed mediation, and that practitioners of mediation may need to seize this opportunity in a way akin to commercial international arbitration. Session Chair, I end my comments here and thank you all for listening to me.
Thank you very much, Justice Patel, for your very insightful paper where you talked about the reforms, the robust judicial activism, and the experience that you have faced and the experience you have gained in Zimbabwe. We would indeed benefit from your experiences. Thank you very much for participating in this conference, and we are really enlightened by what you had to say. Thank you.
Thank you so much. And just as a point of correction, Zambia, not Zimbabwe.
Zambia, sorry.
Thank you.
Thank you, Mrs. Justice Patel. I'm sure that there will be questions at the end. Before the arbitration proceedings even take place, the country, any legal environment needs to attract the investment and commercial ventures for them to be eventually arbitrated if there's a dispute. In this regard, compliance of environmental, social, and governance standards, called the ESG, the Environmental, Social, and Governance Standards, are a prerequisite in many ways to ensuring that there is investor confidence in our markets and in ensuring that we in Pakistan are in step with the rest of the world as far as investments are concerned. To talk about ESG standards and compliance, regulatory compliance therewith, may I please invite Mr. Ravi Madasame to please address this conference.
I'm right now in London. I've been watching this event since morning, 5 a.m. And I must say that I'm extremely impressed by the organization of this event. And I would like to congratulate everyone for putting up such a fantastic and impressive conference. I would like to thank the Honorable Chief Justice of Pakistan, the chair of the session, Honorable Judge of the Supreme Court of Pakistan, the Secretary of the Law and Justice Commission of Pakistan. And I would like to first state that as part of my ESG work, I don't just talk about ESG in terms of the compliance. I take a lot of effort personally in advocating for ESG as an ambassador of ESG across Asia in particular. I just returned from a 3-day UN conference on responsible business and human rights. And I would like to also share with you what took place in Bangkok and some observations, and that would be also relevant for this discussion that is taking place in this eminent judicial conference. Now, what is important for all of us, I would say from my bottom of my heart, is this sense of emergency that we all must feel. And I will say with a very imposing tone that we must, because we just witnessed in Pakistan a calamity of a huge disaster of floods. And of course, that is so, you have gone through this. I mean, I'm just an observer from outside, and yet it is so disturbing. Now, what underscores all this is that all of us here as lawyers are now have to take upon ourselves to be climate lawyers. We all are first as climate lawyers now, more than anything else, because without the climate, we will be completely annihilated, and that is very clear from the disasters that has just taken place in Pakistan and that is taking place elsewhere. This global warming and the climate anomalies that's taking place. And we are also climate citizens. In that spirit, let me deal with this 3 capital words of E, S, and G that is now sweeping the globe, and the relevance of it, first of all, to put in perspective, why is it so important, this element of this notions of compliance in these three capital word areas, and how does it improve FDI and as well as investor confidence. And in that connection, I would like to just summarize the ESG integration into the business and how it benefits business. First, it's easy to raise capital and build opportunities, and it strengthens financial performance. ESG mitigation against ESG related litigation, reputational integrity and attractiveness for foreign investment, greater possibilities for going global. With this focus, these four areas of focus in mind as to why ESG has to be integrated into business, I would like to just emphasize that this whole thing about ESG, and I tell you, my dear friends, I think it will be easier for me to speak to the Pakistan audience more than anyone else, because previous speaker made a very important observation. And what that stuck in my heart is judicial activism in Pakistan, which may not be appreciated in many parts of this part of the world of Asia. But I would definitely, as a human rights lawyer coming from Singapore, trying to, with a very lone voice, champion many issues in the field of human rights, I respect the judicial activism of the nature that's happening in Pakistan. So ESG is essentially human rights in the field of business. It is so important that human rights lawyers come together with business commercial lawyers and have an important exchange. And in that exchange is where this dynamic activity of ESG is taking place. So human rights lawyers play a very important role in this discourse. Very often, corporate lawyers tend to dominate this field. But if the voice of human rights lawyers are not in this arena, it is if those voices in the, because human rights lawyers represent the communities on the ground, are not heard in the boardroom, then ESG has failed its relevance. Now, I would like to, before going into the second segment of my presentation, which is to relate it to a topical area of my interest, which I'll come in a moment, I would like to just apprise you of some of the developments in terms of where Pakistan stands in terms of ESG, because I just got some interesting updates at the UN conference that just took place this week. Now, Pakistan, you got to be fair to Pakistan in the sense that in this field, Pakistan is actually ahead in its implementation of a rigorous national action plan. Of course, it's a national action plan. It may not have the teeth, it may not have the bite, but between countries, and I don't like to compare, but it is sometimes important to see the trajectory in which where Pakistan is leading. Now, the country is Japan, next is Thailand, and the country that next stands in terms of taking the national action plan seriously is Pakistan. And so this exciting development that's taking in Pakistan must be taken to the next stage, and this opportunity should not be lost. And in this connection, I would like to share some of the aspects in terms of the environmental and governance aspect, because the social aspect, which is several labor standards and so on and so forth, there are a lot of host of stuff that you would already know. But it is important to just take a step back and just see where we are and what developments Pakistan has made in terms of the environmental focus. Now, what is interesting is, it is interesting and fascinating to discover that in 2021, the former Chief Justice of the Supreme Court of Pakistan confirmed the existence of the Green Bench. Green benches are found in general courts and comprise judges trained in environmental law, basically green judges. Pakistan also has environmental tribunals, one in each province. That is in terms of the environmental focus. Now, in terms of environmental and climate litigation, because of the constraint of time, I'll just quickly, touch the key aspect of this. A 2019 case revealed the extent Pakistan judges have become environmentally aware, the same way many other judges have been making bold decisions around the world when companies are pitted against the best interest of the environment. In DG Khan Cement Company versus the government of Punjab, 2019, the petitioner owned and operated a cement manufactured plant in Kahun Valley. The provincial government issued a notification in 2018 to demarcate a negative area and no cement plants could be expanded or be newly established. And when the petitioner sued the government, claiming that the notification was unlawful and infringed on his constitutional right to freedom of trade, business and profession, the judges confirmed that they had an obligation to protect the environment. In terms of financial industry, i.e. the broad scheme of governance in ESG, in 2017, the State Bank of Pakistan, SBP, issued green banking guidelines acknowledging the responsibility of the financial sector in supporting policy initiatives for transforming Pakistan's economy towards low carbon and climate resilience. Green banking envisions the instilling of environmental consciousness as part of organizational culture. Now, I'll skip then to the point on sustainability. On 28 September 2021, just 1 year ago, Pakistan, Pakistan, through the Ministry of Human Rights, published its inaugural National Action Plan on Business and Human Rights 2021 to 2026 and held its first committee meeting in January this year. It is early days, but the National Action Plan is expected to reshape the business environment. Pakistan has also significantly signed the multi-annual indicative program, MIP, for 2021 to 2027 with the European Union, which duration is supposed to be 7 years, thus ending in 2021. What is crucial that I would like to share with you is that these are the developments that is taking in Pakistan, well and good, but Pakistan has an urgent need, just like all the Asian countries in the Asia-Pacific meeting that we just gathered. There is a sense of urgency now. Instead of the national action policy, yes, we have talked for all these years, now it has to come to implementation. What is the implementation? It is human rights due diligence. Now, this particular, the free trade agreement that Pakistan has entered into, the arrangements with the European countries, has an element of significance of HRDD, human rights due diligence requirement that would implement the 17 SDG goals. Now, for example, in Germany, this is already taking place. Human rights due diligence is mandatory for employees, for companies, public listed companies, for example, or even companies having more than 250 employees. Now, it is because of the mandatory nature, this aspect of foreign investor confidence and FDI is subject to HRD, particularly when it is with the European countries. And if you need to tap the investors, the investments of arrangements with Europe, this becomes a very important aspect that Pakistan needs to implement. Japan, in Asia, amongst the countries, Japan has taken a leadership in implementing HRDD shortly. And Thailand has also taken very strong steps. And it is also, we are looking forward to the implementation of human rights due diligence. And there will be lots of legal work in terms of corporate and human rights oriented, business and human rights oriented legal work and training that also needs to be done in Pakistan to also absorb these opportunities and harmonize these developments that are taking place both in Europe and Asia. So the urgency is human rights due diligence that needs to come into law. And there must be political will. And there has to be a political will to move this forward. Because it is all good. There is no there's no legitimate reason to delay this. That is also the consensus of the countries in the Asia Pacific that came for the meeting early this week. The next point that I would like to emphasize is there is this aspect of climate ESG, which I just like to touch very briefly. Because of the challenging climate situations, a company's own existence may be jeopardized. Earthquakes, heat waves, or floods are common in Pakistan. So everyone has a part to play in this climate care. The Global Climate Change Vulnerability Index puts Pakistan as the 16th most vulnerable country in the world in the 2010 to 2011 index. So this is something that the ESG aspect of it, with all this auditing mechanism that is available, will also help to mitigate the harshness of this climate vulnerability that Pakistan is facing. I would like to conclude with this final aspect of my presentation to focus on something a bit controversial, but I hope that, I know that this is a very democratic environment that I'm before, so that I will take this opportunity to share with you on this aspect, which is also close to my heart, is the development of the blockchain sphere. Blockchain sphere and ESG there's such interesting mega trends which are developing in these two arenas. Because the nature of blockchain itself is self-regulating, hence it's trustless. Trustless to the extent that it does not need to be regulated because the technology is so regulating to its finest sense. And ESG, it's also a very regulatory measure. So the mega trends between these two, and especially the blockchain with the interaction of the ESG, is very, very interesting to watch. And within this space, I see an economic opportunity in Pakistan, which is actually the digital assets arena. And I will put it bluntly, it is actually, and there's nothing wrong to talk about. This is cryptocurrency. And cryptocurrency, Pakistan is the country which has the third largest cryptocurrency users in the world. And coming from Singapore background, there are lots of the cryptocurrency has been regulated by various, both ESG funds are regulated by the Monetary Authority of Singapore, and Singapore has got some interesting, useful legislations in terms of also regulating the blockchain sphere, especially the cryptocurrency. Now, the reason why I'm mentioning is that Pakistan, being an Islamic state, does have this concerns about cryptocurrency not being asset-backed. So what I'm suggesting is that, and I was also talking to Mr. Abdul Jasrit, the Deputy Secretary of Pakistan, who's also the organizer, about some of my ideas regarding this. And I would like to just bring on board these discussions that this cryptocurrency usage could be regulated, and that regulatory aspect of this tax and the benefits from, the economic benefits from this currency and usage could be back into the economy of Pakistan without losing it. Because first of all, it can have a Sharia compliance. It can have an asset-backed process. It can have a Amana token, so to speak. And here is where I see that there is an economic space, what we call a exchange. The exchange that is a space which is found in this cryptocurrency blockchain space, which is an impact exchange where the 17 SDG goals can be tokenized, whereby a person can just buy or exchange a token, and for the purpose of donating to the 7 SDG goals. And the other aspect of it could be where a Sharia compliance mechanism, which I mentioned, that an Amana token is mine, by the way. I'm just creatively exploring it, and that could also be investigated and put for discussion. So with this notion, there is also this aspect of financial literacy to villagers, to improve this financial literacy amongst women, and they could also benefit from this sort of Sharia compliant asset-backed digital assets, and they could also learn this and participate in the activity if one can regulate it and benefit from it. So the reason why I'm mentioning this is that I'm basically bringing this topic to circular economy, whereby this ESG-backed Sharia compliance digital asset, which is actually a very key component of the business of Pakistan, we should not be lost. So that is my humble observation. And thank you so much for listening patiently to me. And I would like to thank all of you for this organizing this wonderful conference. Thank you.
As diverse as ESG and judicial activism and environmental issues and green judges, and then finally cryptocurrency. I think you've left a lot of food for thought for us, and we'd be relishing and thinking about the ideas that you have planted today. Thank you very much, and it was a very useful presentation. Thank you.
Thank you, Mr. Ravi Madasame. May I sort of take this opportunity by virtue of having international speakers to apologize to them who are online and those who will be waiting for the next session as well. We've been running a little behind schedule, and this must have caused a little bit of inconvenience to you. So to all the speakers here and the participants, on behalf of the Law and Justice Commission, we want to apologize for the time delay, but the topics were so interesting, as I'm sure that all of you have been so engrossed, that there was no way to pull it away or to shorten it by any more. Without much ado, may I please introduce Ms. Leonara Reisenberg. She has been very kind to come all the way to Pakistan for this conference. She's an internationally recognized arbitrator. In fact, in the UAE, in the Middle East, she is probably the top name in arbitration. So without any further ado, Ms. Reisenberg, the floor is yours.
Hello, good afternoon. I hope you're not in a food coma after that beautiful lunch. Thank you so much to the organizers for keeping us till after lunch. It's always the trickiest spot of the day. Dear friends, peers and colleagues, it's such an enormous pleasure to be here with you today. I'm particularly pleased that we're able to travel, that we're able to sit with our neighbors and our friends and our peers, and to exchange intellectual intelligence about ADR, about the judiciary, about our practices in our respective jurisdictions. Now, for those of you that know, I'm based in Dubai in the UAE. I've now been in the UAE for over 15 years, split between Abu Dhabi and Dubai. I am, however, a barrister from London, so I do have a UK background, and that certainly has been a great help coming into the UAE, as you can imagine, at a time when women were not empowered. So I did listen very patiently and with great curiosity at some of the speakers and listen to the plights that women have. And I can tell you that if you apply yourself and you work hard at it, you put your head down, you keep going, you will succeed. And we are stronger together, not just as women, but as people, irrespective of gender, background, and race. Now, before I start, allow me to thank the honourable members that are here today, his lordships and his ladies, to all distinguished members of the bench, distinguished members of the bar, fellow peers, colleagues, practitioners, to all the participants that have carved out 2 days out of their diaries to be here with us and to share their own experiences. It is such a pleasure, I cannot say it enough, to meet with all of you. And if I haven't had the opportunity to say hello, please do come up and introduce yourselves at some point. Without further ado, I am hoping that my slides are going to turn up, and I also do need to take the opportunity to extend thanks to the new branch of the CIAB in Pakistan. Delighted to hear that we have a branch, delighted to be here on invitation of the judiciary, the Lord Chief Justice and the branch. And I also thank my fellow peers and colleagues who you will see around the room, who you've seen for the last few days and you will be seeing for the next 2 weeks if you're undertaking mediation training with the branch over the course of the month. Thank you so much for having me here. So let's start with the first slide. I was stuck with one of these subjects that's very difficult to tackle, so I've taken it from a slightly unorthodox route. And I am going to start very briefly by talking about investor confidence without wishing to tread onto a subject that other people are going to be addressing on the panel. But if you're able to look at the chart that's now up, I'm afraid it's very small, so you might not be able to tell what those lines are, but effectively you're looking at 3 separate lines. And in terms of the jurisdictions where ADR has done very well, you will see Hong Kong right at the top, followed by Singapore, and the blue line at the bottom is Pakistan. Now that to me indicates that there are tremendous opportunities ahead of you. This is a really interesting time for Pakistan. I'm thrilled to be here at a point when that curve is relatively flat, because I know that next time I'm going to be here, it's going to be high and it's going to keep going up. And I'm pretty sure that you're going to be able to get right up there along with Singapore, Hong Kong, and other jurisdictions where ADR is thriving. But we do start with investor confidence because obviously that is important. It's a cornerstone to ADR being successful, and vice versa. You do need to have the right framework in place to make sure that investors are invested in coming to Pakistan to have their disputes resolved. So it's very much a chicken and egg situation. Next slide. There was a very interesting case study that I'm sure many of you are familiar with from White & Case that was issued in 2021. I am hoping that the next slide is going to come up. You will see, sorry, slide after that. You will see a summary of that case study, and that it was interrogating international arbitration. It was a survey and looking at the adaptive needs of commerce and the mercantile community, and also comparing how various countries are doing, as well as giving you an overview of what the most famous and most celebrated seats are international at this point in time. And bear in mind that that is a changing storyboard. It's an ongoing competition. We can all excel in our own way and see whether we can get that percentage higher up. And again, I have to apologize because you're not going to be able to see the fine print, but I'm sure that these slides will be made available to those of you that ask. But you'll see that, again, Hong Kong, Singapore are doing very well. UAE also is doing very well. So they're all named over there. Is there a way we can zoom in? Sorry, because it might help. No. Okay, never mind.
I will just try.
So the percentage rates are high up, and that shows confidence levels are about 20 to 50% thereabouts between those countries. You'll also see that from the institutions that tend to be the institutions that investors gravitate towards, you will not be surprised to hear we've got the likes of LCIA in London, ICC based in Paris, but with regional offices around the globe, including one in Abu Dhabi. You'll also find SIAC there in Singapore, as well as other centres. So they are firmly on the map. I would like to think that the UAE, so DIAC, I'm sure you're all familiar with DIAC, the Dubai International Arbitration Centre, is not far off, and certainly one of the contenders and go-to centres that you would go to. On the right-hand side, top right-hand side, you'll see a number of diagrams, and that indicates areas where we still need to work at things. And a lot of questions are asked about should arbitrators be regulated. That's certainly been a question that's been bounced about. And on average, people are satisfied with their arbitrators. They are, however, saying, well, we need to consider further regulation and certainly further guidances for arbitral secretaries that are coming into the ADR field and may not be as seasoned as arbitrators. And that's certainly one of the areas where we still have quite a bit of work to do. Foreign investment. Foreign investors don't necessarily like investing their own money, so third-party funding is also one of the areas of great interest that needs further work at. And that would start with regularization, so it's something that needs to be done top-down to make sure that those 30 funders are protected when they come into the market and they do fund proceedings. So very interesting analysis. If you haven't had the opportunity to look at it and to read it, by all means do so. It's widely available online. Next slide. Okay, next slide, please. Good. So, how do we bring investor confidence into a market? Well, we have had a very challenging time during COVID, but it's also allowed for opportunities in the form of technology being introduced to fields, including our field. And, you know, speaking as a barrister from London, and I am a member of Lincoln's Inn, I have met a number of you, it's very nice to see friendly faces around the room. There was a time that if someone said to me, you're going to be conducting hearings online, I would have told them that they're absolutely mad, it would never happen. And here we are, we're able to exploit the technologies that we have available in the market and to use them in order to make processes, including processes in ADR, more time and cost efficient. And there has been an outcry around the globe for time and cost efficient processes, certainly at a time when ADR processes and litigation is becoming more and more expensive and more difficult to fund. So that certainly is a very helpful tool. It's been a great transformation, certainly at a time when we were tested, but it lent itself to modern techniques and modern methods being brought into practice. And that's something to be celebrated, not only in terms of cost and process efficiency, but also in terms of access to justice, to make sure that those that cannot fund proceedings now find it more affordable and more accessible. And we have seen worldwide promotion of more efficient practices using technology. And that has to start with remodeling laws and practice and procedures to cater for virtual conduct of proceedings. And I don't just mean protocols for holding virtual meetings, whether it's your preliminary meeting, your arbitration hearing, your mediation meeting. I'm talking about all sorts of aspects of process management from start to end. And it certainly is something that is now being introduced around the globe. We've got completely digitalized systems where effectively you don't have a single piece of paper in front of you, everything is done on a screen. Usually you've got 3 or 4 monitors in front of you, but it's all digital. And that lends itself to that keyword efficiency. So there are many benefits that have risen from COVID, something to be celebrated. When I speak to parties and I ask them whether they have any preferences in terms of having a virtual meeting or hearing or an in-person meeting or hearing, I get very mixed responses. And it's really wonderful to be able to cater for everybody's needs and interests. And some parties will say, well, look, there are a number of benefits of doing this remotely. For a start, we've got people deployed all around the globe. And that happened to me recently on a pipeline dispute where people were on site, and it would have proved very difficult to bring them into a physical space for them to give evidence in person. So from that point of view, it's great because it does allow for people that need to be in that room to be able to have a voice. And it all goes to having a fair chance to present your case in the best manner possible. So that's all about access to justice. Others will say to me, no, culturally it doesn't work. And that's something that I get exposed to all the time in the UAE. We need to do it in person. What do you mean giving evidence virtually? That simply doesn't work. And that's brought about a new trend, and a new developing trend is that we have hybrid meetings and hybrid hearings, and they tend to work very well. So we do allow for the opportunity to do both. It's a 2-in-1. It becomes a little bit more burdensome from a logistical point of view, but there is nothing that we can overcome. We've survived the worst of COVID. I'm sure that we can survive a bit of administration. So weighing cost and time considerations obviously is very important for investors coming in, but we also need to consider what we need to do to maintain the integrity of the process. And when we consider ADR, we are looking at a private dispute resolution process. So the party's contract will be the law that you abide by. So these are the parameters of the framework within which you operate. And maintaining that integrity is not straightforward. There are many moving parts, as you can imagine. But ultimately, you do need to ensure that a fair trial is preserved, first and foremost. And that in itself underpins why this new emerging practice of having hybrid meetings is coming about. At the outset, parties don't necessarily need to spend that much time and money to get into a space with you for a preliminary meeting or a case management meeting. That could be done remotely. But when things get a little bit more complicated, when you've got cross-applications, when you have witnesses, factual witnesses, expert witnesses that are giving evidence, I always have troubles with experts. That's something that I'm sure some of you would have experienced. When you have experts, particularly that don't speak the language of the proceedings and they need a translator. Not easy. There are many moving parts that need to be looked at, and you, as an arbiter, need to make sure that everything is kept in order. The same applies for mediators. If you're mediating, you need to make sure that everything is up to scratch. There's no room for error. And it is very much a people's profession. We're not robots. We do need to bear in mind that certain people have needs, and those needs need to be addressed to make sure that you can get the right answer or to the right result. So not without problems. I did start talking about technology, and technology itself has its own risks, and those risks need to be mitigated. I was thinking specifically about security risks. Confidentiality is obviously sacrosanct, and it needs to be defended. So yes, it's great to have the option to have virtual platforms and everything done electronically, but we do need to think about security risks and issues. As a tribunal member, I will issue protocols. I may even ask people that have their cameras switched off because they're only listening in to switch them off, to move the camera around to see who else is in the room. There are so many aspects to having virtual hearings or hybrid hearings that you need to bear in mind. But we are blessed. We are fortunate with a lot of guidance from the international communities. As you can imagine, there are a number of institutions and key players, including the CIARP. I know the ICC also has guidances. UNCITRAL, of course, is leading the trend. We've got the model law, the model rules. We've got so much material that we can have regard to when we are looking at how we should construct our own practice. So arbitration in the UAE, let me talk about what I now consider to be my second home jurisdiction. As many of you will be aware, the UAE is quite special in terms of having both a civil court and a common law court, and that's certainly true of Abu Dhabi and Dubai. So in Dubai, we've got the DIFC courts, they're your common law courts. We've also got the national courts. In Abu Dhabi, we've got ADGM, they will be your common law courts, and we also have the national courts. You might be thinking right now, well, that sounds a little bit confusing. No, it's empowering. Not only does it add to investor confidence, but it allows investors to choose their forum. They can choose a common law forum, they can choose a civil law forum. I was speaking to some of you earlier about the conduit jurisdiction of the DIFC. Well, that also is truly empowering, and what a great relief it is to some investors that might be skeptic of the local courts for whatever reason. DIFC can be used as a conduit where, effectively, if you had a foreign award, you would come to that court, ask the court to ratify it on the back of all of the bilateral treaties and conventions that are in place between the UAE and other member states. We heard of one, the New York Convention. I know Pakistan is a member, which I'm pleased to note. Or you could go to that court, they rubber stamp it, and then immediately go and execute it in the local courts. We have a very fast and speedy process for enforcement of foreign awards. And that is something that provides great comfort. It also shows great commitment from the UAE to the promotion and development of ADR. And they've aggressively been promoting international best practice and allowed for a very healthy arena. Touching on some of the developments in the last year, and you'll see there is a clause up there, that's from the DIAC rules. Those rules have recently been updated. I need to make an admission, I didn't prepare those slides. I'm not sure whether it's the latest model clause or whether it's one of the older ones. But we've certainly had a remodeling when it comes to institutions in the UAE. I'm sure some of you who practice both here and abroad and internationally will know that we had notable developments. We had the consolidation of a number of arbitration centres in Dubai. They've now been consolidated and are under the remit of the DIAG. And those centres include the DIFC LCIA. I'm told I've got 2 minutes, I will try and speed up. And they also include EMAC, that was the Emirates Maritime Arbitration Centre. And it shows great leadership. What Dubai UAE has done is they've allowed a lot of room for international players, key players in the field of ADR to come in. And then review and consultation is obviously very important, both from the local community but also from the international community. It came to the idea that they actually wanted to centralize and consolidate all of these centers under one roof. And now DIAC is a powerhouse, and DIAC is collaborating with the LCIA. So we still have that collaboration in place. It's just been reframed, remodeled. Next slide. I do want to share, in terms of efficiency, how speedy the process is for enforcement. I think it's important to point that out. So you'll forgive me if I run slightly over my 2 minutes here. But when we had the new arbitration law issued in the UAE, that's Federal Law number 6 of 2018, it was issued in May 2018. Shortly after that, in December of the same year, we had a cabinet decision number 57 of the same year, 2018, for those of you that are curious to know. And what those two instruments have done effectively is they've said, look, if you have an award, you don't have to go to the Court of First Instance. You can go straight to the Court of Appeal. So you're speaking to the Court of Appeal judges here. You can file a submission or a petition to have your award enforced, and that will be done within 60 days. That's incredibly fast. And just to make sure that they have canvassed what would happen in case if there was an application to set aside the award, they've also put it on the disgruntled party to go to the court and put in an application to set aside that award within 30 days. So if that party doesn't do it within those 30 days, you know you're going to get your award enforced. And that's working out very well. I'm not saying that the UAE doesn't have more work ahead. I think we all do. We all need to keep improving the way that we practice. We also need to make sure that we've got the right framework in place, and that can only happen by virtue of the government and the judiciary communing together in consultation with all of you, ladies and gentlemen, who are practiced and learned. We face challenges by virtue of powers of attorney being challenged, the authority of signatories to arbitration agreements being challenged, and we have seen some awards that start on that basis. We also have local idiosyncrasies, I'm sure you do too in Pakistan, where if every single page, I'm running out of time, I'll just finish very quickly, thank you. Well, if every single page on an award is not signed, that too may well mean that your award will not be enforced. But if you know how to play the game, you know how to cater for those situations. So time is up. It really has been a pleasure. I need to compliment all of you. I can see so much promise. It really has been enlightening to be with you, to speak with you, or to listen to all of you speak. I am so hopeful that the future is bright for ADR, for Pakistan.
Thank you very much, Ms. Riesenberg. It was a very insightful and thought-provoking analysis of the latest trends and the best practices in international commercial arbitration. We are certainly enriched by this very scholarly and practical presentation. Thank you.
Thank you, ma'am. And our sincerest apologies once again to everybody who we're pressing on time. We have speakers waiting internationally on Zoom for our next session as well, and we want to sort of try and meet the dinner deadline as closely as possible. So, with sincerest apologies in regards to time management, may I please now invite Mia Shiraz Javed. He is going to focus and talk a little bit about the economic zones that are coming up in Pakistan, and in particular, the role of CPEC that's going to be very important in the years to come. Sir.
Bismillahirrahmanirrahim. Your Lordship, Mr. Justice Umar Ata Bandayal, Honorable Chief Justice of Pakistan, the Honorable Judges of the Supreme Court, the Honorable Judges of the High Court, members of the legal fraternity, ladies and gentlemen, Assalamu alaikum. I'm really excited, privileged, and humbled to be here in front of such esteemed audience where all my learning and sharing, where we are all learning and sharing our experiences to help and improve various challenges being faced by Pakistan. So I'm Mia Shiraz Javed. I'm a practicing barrister in England, working with number 5 barrister chambers, and I also work as a partner with MK Consultants LLP in Pakistan. I'm the founding chair of the Chartered Institute of Arbitrators, where we are focusing on improving the institutionalized dispute settlement mechanism in Pakistan to match the global best practices. It was not an easy journey to convince the Chartered Institute to allow us open an independent branch in Pakistan. The amount of judicial support we have had by, in opening up the Pakistan branch, we are really pleased and grateful. It was an honor for us to have the opening of the Chartered Institute of Arbitrators Pakistan branch in presence of the Honorable Chief Justice of Pakistan and in presence of the Honorable Chief Justice of the Lahore High Court and Honorable Judges of the Supreme Court and the Lahore High Court. The words of wisdom by the Honorable Chair of my session was comforting, Mr. Justice Ijazul Hasan. It clearly shows the mindset and support of the judiciary towards ADR. So ADR, alternate dispute resolution work, is about profound quest for justice and social transformation without traditional court system. Dispute settlement mechanisms are structured processes that address disputes or grievances that arise between 2 or more parties engaged in business, legal, or societal relationships. With the increasing digitization and globalization means that an increasing proportion of transactions and contracts are internationally mobile, which means where parties are free to choose a particular governing law and legal services that best suit their requirements from anywhere in the world. They can be in Pakistan, but they can always opt to choose the governing laws of England and Wales to go through with their arbitration process. These trends have significant impact on the economic value of trade and commerce. Dispute settlement mechanisms are the safety nets of trade, commerce, and economic development and investment projects. In even simpler terms, dispute settlement mechanism is the catalyst for economic growth. So how to promote the investment climate in Pakistan? COVID-19 and floods, they are not the only pandemic and the disasters that our industry have faced. Our sectors are marred with delays, cost overruns, disputes, and liabilities. There is an increasing need to have a certainty on how to enforce contracts in a way that protects the intended goals and objectives. Uncertainty leads to higher transaction costs as parties increase their cost by adding unprecedented risks, leading to fewer direct investment and higher cost outturn. The biggest infrastructure project in Pakistan, the China-Pakistan Economic Corridor, is mostly based on infrastructure and energy projects. They are more complicated than we can comprehend, and they are on a much larger scale. On projects of such scale, we face a number of issues in the aspect of business operations. However, it is down to the legal framework to make it resilient and be able to identify, evaluate, and mitigate these issues to make good effective dispute settlement mechanisms. The dispute settlement mechanisms provide a degree of predictability and confidence to enable transactions to take place by providing a set of common rules that once generally understood and considered to be enforceable through the legal system. It gives greater certainty about what will happen under specific conditions. This gives a degree of confidence in promoting an investment climate that enable and derive economic value. If we look at the relationship from a more holistic view, the law is critical infrastructure that enables and encourages the growth of economic value through an increase in business transaction. The dispute settlement mechanisms utilizing ADR in Pakistan are not adequate enough to give foreign investors the needed confidence. If we are expecting investors to take the standard judicial route, we are essentially asking them to inject a further infusion of capital, coupled with long delays. The local judicial system is simply too complex and too lengthy for foreign investors to contemplate and to accept. Due to the deficiency or the absence of proper functional dispute resolution mechanism in Pakistan, which has developed the practice over the years of relying on giving sovereign guarantees, this has greatly hindered economic growth on a national scale. We are asking investors to come to Pakistan. We have to show them the investment market that how effective our dispute resolution is for enforcement of contracts. To design the best mode of settlement mechanism for Pakistan, the first principles are to identify the root causes of those disputes. Next slide, please. So in order to get into the root causation of the disputes in Pakistan, we conducted a survey, Pakistan Construction Dispute Survey, although the name gives mention of construction, but it covers all the industries in Pakistan. So it is for the first time that a comprehensive repository of data has been collected across Pakistan, which can be subdivided by sector, causation, and region. PCDR will pave the path to identify the key causes of disputes in Pakistan, various industries to help with appropriate strategies to identify, mitigate, and avoid disputes. PCDR outlines techniques to help avoid disputes arising, and when differences do arise, the techniques to deal with those issues early, quickly, and cost efficiently. The aim is to educate people working across the industry about the life cycle of conflict avoidance and early intervention to prevent disputes. Next slide, please. So the whole data is available on the website, pcdr.pk. It is an interactive dashboard. We can hover around, we can choose region, we can choose sector, and it will give the actual data of how disputes are happening in Pakistan and what sort of dispute resolution methods are being used at the moment. So this data was very much needed before we go on to what type of dispute settlement mechanism is to be designed for Pakistan. So the key causes of dispute that have marred foreign investment in Pakistan, as per the data, are payment delays, program delays, behavior and competency of people in Pakistan. Disputes can involve straightforward issues, but they can also be incredibly intricate and involve complex questions of law. Deciding the right method for dispute settlement mechanism requires careful thought and should be a key part of the contractual negotiation process. Most situations which can give rise to disagreements and full-blown disputes, they can be avoided through well-drafted contracts and a commitment to parties to embrace dispute avoidance and early intervention techniques which can be incorporated into the contract terms. A well-designed dispute avoidance procedure in a contract helps parties to engage in open and honest communication. Such a procedure should provide an agreed system for identifying problems early and dealing with them in a non-adversarial environment that encourages compromise and avoidance of escalation over formal dispute resolution. Due to the shortage of time, I think I need to compose a few things into the solutions that have been designed for Pakistan. Pakistan should now contemplate the establishment of arbitration centers that fall upon international standards. How can we give that confidence to the investors, both local and international, and even the Pakistani expatriates? The answer is clear. The clear answer is the solution must come from the highest institutions that lead the nation. The judiciary and the legislature have the duty and the tools to establish a successful and fully integrated alternative means of dispute resolution to secure the interest of all parties involved. It is being discussed that 3 different pieces of legislation should be introduced: one for the domestic arbitration, one for the international arbitration, and we can always have a separate legislation for mediation. The world is now moving to compulsory mediation, where there are cost consequences if you do not agree, if you do not cooperate with the mandatory mediation in different parts of the world. So besides the legislation, which is going to be the legal framework, which are going to govern the ADR centers, there are also under discussion the type and the model of the ADR center, which should be introduced in Pakistan. And it ranges from the concept of International Arbitration Center, the IACs, and the International Court of Arbitrations, the ICAs, with both models which can be privately owned and government owned. Based on the models of which, for our environment, which can be the best model, we need to give the infrastructure available so that the processes, the courts should be ready to supervise the process. The world is now shifting from court intervention to court supervision. We need to create a local pool of experts. We just can't have an ADR center opened up where we don't have the local pool of experts. We don't have mediators. We don't have trained arbitrators who can produce enforceable award. The judiciary, the market, the business community, the systems need to give the assurity that they are in good hands. The awards which will be produced by the arbitrators, they will be enforced, and things which are being undertaken in the lower judiciary in years of time, that can be reduced to 3 to 6 months of time. With that, I'll conclude. The Chartered Institute of Arbitrators Pakistan is trying to play whatever role it can in the current circumstances, from development of the arbitration centers, making working groups. We have involved the working group of the Global Chartered Institute of Arbitrators, sitting with the UNCITRAL, developing the new framework for the UNCITRAL's third amendment. We are also working on the changes in the Arbitration Act 1996. We are working on development of the new legislations for Pakistan. I would like to end on the quote which was used by the Honorable Chair of the conference. The courts of countries should not be the places where the resolution of a conflict begins. Rather, they should be the last resort when alternative methods of dispute resolution have been tried and exhausted. Thank you very much.
It's on. is on. G.
It's not working.
It is.
Is it? Okay. Thank you, Mr. Javed, for your very useful comments especially on the CPAC-related arbitration processes and your general recommendations regarding the steps that need to be taken to ensure that foreign investors have confidence in our local arbitration procedures, and they have the confidence that in case an arbitration award is in their favor, it would be implemented, and there is a mechanism available within our system to ensure that. But thank you very much. It is very thought-provoking, and it gives us a lot to think about.
Thank you also, Mr. Javed, for abiding by our time restraints. My apologies for having to cut that short. The last speaker of this panel for today is known to virtually everybody in the room, just Honorable Mr. Justice Jawad Hassan. And may I also say that he will be speaking about the need to institutionalize alternative dispute resolutions and to promote economic and trade opportunities. He's also been very instrumental in establishing the commercial courts in Punjab. Justice Hassan.
Bismillah ar-Rahman ar-Rahim. Honorable Senior Puny Judge, the Honorable Judges of the Supreme Court, the Organizing Committee, the Chair, the judges of the various provinces and Chief Justices. 24 hours ago, we were sitting here, we heard about good, bad, and the ugly. Today, I'll speak only about good on rule of law, good on dispensation of justice, and good on the access to justice, on the concept of ADR in promoting the respect in Pakistan. It's a great pleasure to able to address to you all, but first of all, I must congratulate Pakistan on an extraordinary initiative taken by the Lahore High Court in establishing the first commercial courts and the arbitration and the overseas cell with the support of the Supreme Court of Pakistan. And my task in 12 minutes today is to put a wider context and look into, in terms of current developments worldwide, like the London Commercial Courts, established in 1895, gained the respect and prestige, and 80% of the users of the London Commercial Courts are the foreign parties. Then the Singapore, the English-speaking German courts, the English-speaking French courts, and the other courts in the world, which we have taken the examples of setting up our commercial courts, a successful model. When Justice Jadul Hasan Saab came to us with the Lahore, with the Chief Justice of Pakistan, when we trained the judges 22 years ago, now we are on a path to talk about goods today. One cannot, where are my slides? Next, please. One cannot underestimate the critical importance of an effective, speedy, trusted dispute settlement system to the constituency outside one's own country, to outside international users, and to tailor and structure to procedures, make them bespoke in order to cater specifically the needs of those international users aspiring for building confidence in foreign investment in Pakistan. Other international users are looking Pakistan commercial courts. As you can see, my senior puny Justice Malik Shahzad is sitting with us because when we set up this commercial courts and overseas cell, the then Chief Justices were all supporting us with the Supreme Court. And now my senior puny, who's been continuing as this, is sitting just to know how he will support the next future of these two new initiatives we have. We represent, when we travel abroad, setting up commercial overseas cell in 2019 and commercial courts in 2020. Recently, I was with Justice Masuli Shah in London. When people ask, who are you from? We say we represent 112 million people, Pakistan, with 36 districts, 80,000 square miles of the most populous state, fifth state in the world. We have shown the world, walk the talk, by setting up the commercial courts giving judgments on them, being implemented. Even the Supreme Court of Pakistan recently acknowledged Justice Qadi Faisal and Justice Afidi's judgment. We'll explain that later. This how Lahore High Court taken initiative. But I must say before I start, our doors are open for other provinces to follow. They can come to us. I can leave the documents, how we prepared, the booklets we made for other provinces to do, and I can even come to you with the permission of Chief Justice and tell you and guide you, if you like, at the end, what we've done. Judicial perspective. When we travel anywhere in the world, the only way to build the confidence of the investor in the world is to attract the foreign investor is the capital will only flow when they look at the good ecosystem in the country. To have again, I use the word, trusted, speedy, effective dispute settlement mechanism. And that can only be achieved when we did those with the help of the World Bank and other donors to set up this, and both were supported by the High Court, the Justice and Supreme Court. And then, before the second is, first slide, Verona, I'm still in the first slide. When any investor looking into Pakistan internationally, which our users are also international users, 50%, the barometer and the gauge to measure the Pakistan investment as per World Bank report and US report is the corporate law firms. How good is Pakistan judiciary protecting the foreign investor and the sanctity to the arbitration agreements? And that is the judgment of Justice Aisha Malik, who passed the judgment in Lahore High Court, which was mentioned by Justice Judicial in the morning. That's 2021, CLD 10669, enforced the international award obtained and which was then upheld by the Honorable Speaker of Pakistan in 2021, SCMR 1728, by laying down some principles of the foreign arbitration under the New York Convention, and what principles they have laid down. Justice Judicial Saab has read out. I have no, so I can skip that. Now, second question asked by the international community in London, in Singapore, in Dubai, when we're speaking, is, does your law permits that? And the answer to it, Pakistan is 75 Diamond Jubilee celebrated by the Supreme Court. The Constitution of Pakistan, Federal List Part 1, mentions international agreements and treaties. Pakistan's Constitution very clearly mentions and opens the door for any person, that is Article 4, inalienable right to be treated as per law, wherever he is or for time being in Pakistan. Wherever he is, somebody who's outside Pakistan, and when I examined the Part 1 of the Constitution, the word used there was immigrant who goes out of Pakistan, and an immigrant who comes into Pakistan, and that is Article 4. Wherever he is, that's written in Article 4, or for time being in Pakistan. Second provision, which I always tell to foreign parties when we're addressing them, is the Article 37D, and then the most important is, how do we interplay who can achieve our doors? We always say that person is used under articles of the Constitution, fundamental rights. A party is used under Article 199. Individual is used under Article 10A. And the word also citizen is used under Article 260 of the Constitution. And if you intertwine them together and you interplay them together, any party, Article 199 says, subject to the Constitution, any party can file a writ petition before the High Court. So foreigners can come into it. While giving a Pizza Hut judgment, we explained the concept of foreigners entering Pakistan and not us using a judicial restraint. Then the most important topic, again, whether we have any setup to look after the secretary of under the rules of business, federal rules of business, Schedule 1, there is the Board of Investment and Investment Division. The District Secretary is sitting here, Amreen Iftikhar. And then under the Punjab Government Rules of Business 2011, Schedule 1, Secretary Industry, who is the administrator of the Commercial Code Ordinance, is also sitting since morning, wanted to know what our point of view is. Then moving back to Economic Reform Act, and also we have just been informed by the Board of Investment, federal government, that they are also resolving the foreign investment grievances through the foreign investment ombudsperson, that is at the end, which is a draft for the foreign policy. That is it. Next slide, please. Under the access of justice for overseas Pakistanis and business community. Extraordinary initiative was taken by the Lahore High Court, as I mentioned. The constituency of both the courts which we established in 2019 and 20 is of foreign users. Like London commercial courts have 80% users are foreigners. And the world have trusted London now because they thought their jurisprudence under the English common law, and that is the prestige and enhances the prestige for Pakistan if we do set up SET. SET is called Speedy, Effective, and Trusted Dispute Mechanism through a court or through an ADR, which we are trying to solve at the next 10 minutes. Then we have Supreme Court of Pakistan, which has the HRC cell, which in first time in 2011 mentioned an overseas and took up a matter of an overseas. Then we have the High Courts of Pakistan. We have lots of cases where we always do, and the Supreme Court always does, is an ENE, early neutral party evaluation, when a parties are now, when judges understand the case, when you can do an ENE, which is a practice now under international world, international community, where they can have a mediation. Not an arbitration, it takes long, a mediation, a reconciliation, or a settlement between parties. That is something very important for the understanding a commercial matter. Then we have appellant tribunals. Here we have the specialized courts. Rahat Kunayan is sitting here. She's the chairman of the CCP. They have an appellant tribunal. They are also dealing with the matter. When we're looking at it, the Lahore High Court then set up 2 judgments giving a time frame, and I was authoring those. The time frame used in the world is 120 days for a commercial matter. First judgment, Lieutenant General Mahmood Akhtar was given by the Lahore High Court, where the preamble of the Companies Act mentions the expeditious resolution of corporate disputes, and 120 days is the time frame of the law. And then in the Pizza Hut judgment, the Lahore High Court held that, as described at length, the significance of the establishing commercial courts and objects of designing judges for commercial courts in Punjab, withholding that Article 37D of the Constitution also provides this duty to provide indispensable justice, and it's the duty of the courts in Pakistan to see the rights of the parties and to protect their interest in order to build confidence of the investors in Pakistan. At the same time, the interest of the functionaries has also to be examined regarding financial interest of the government and public exchequer. That was what we had to hold in the Pizza Hut judgment to protect the foreign investment, yet looking at the interest of the government too. And next, please. Third is the initiative of the Lahore High Court. This is a cell we created 2019. This cell, as a website of the Lahore High Court, you can see the history, the judgments, the speeches, the useful links, filing of the complaint by anyone, transferring a case from a civil court to overseas court. 36 districts has one full-time judge looking after overseas matters, and that full-time judge is now handling only overseas matter and claim then that will be a fast-track case to deal with. Next, please. In the overseas, first, as I mentioned, Justice Jilani took up the matter in 2011 at the Supreme Court. Then the Chief Justice Sakim Nassar on 27th May 2017 and 13th of March 2018 in the NJMPC meeting has mentioned and deliberated about the overseas matters and the policy, which is then a part of the record. Then the Punjab government was the first one made the Overseas Commission Act, which was repealed. Then the notification of our High Court for the establishing the 36 full-time overseas cell came, and then the Punjab Overseas Commission Act ordinance came, and then the judgment of the Honorable Supreme Court of Pakistan 2022 SCMR 1282, which is the bench headed by Justice Qadi Fairisa, where they say we are informed that High Court has taken certain administrative measures for early decision of the cases of overseas Pakistanis and to address their complaints regarding undue delay in decision of the cases. The legislature of the province has also enacted a law, and the actions are appreciable, and we expect other provinces and Islamabad capital territory would follow the suit. Then there are judgments of the Supreme Court of Pakistan on this, and then the High Court, Islamabad High Court judgment, authored by Justice Atar Millah, PLD 2019, Islamabad 544, mentioning the first judgment of a High Court of the overseas, and then we pass certain judgments by looking into the anthropology of overseas, the anatomy of the sections, the pathology of the provisions of the law, and then the anthology of the judgments relied by the Supreme Court of Pakistan by holding in Tanveer Chishti. When I was writing this judgment, because people misuse the overseas cell by showing their passport, we had to mention that overseas are the one who are dwelling abroad, working and sending money to Pakistan in order to invoke the jurisdiction of overseas in Tanveer Chishti, followed by other courts later on. Then next, please, I have 3 minutes, the commercial courts. The commercial court was then the first commercial courts in Lahore, was inaugurated by the then Chief Justice when he went to civil courts. And then the work of commercial courts have the judgments of the commercial judges at the district level and the High Court level, all available on the High Court website and also on the CLD and PLD every month. And next, please. This is the crux of the commercial court. Here is the commercial court and the ADR have the symbiotic relationship. Commercial court are interdependent on the ADR. When the matter is things they delayed, they can refer to the ADR, and that is where, without successful, efficient, trusted courts, you cannot look into the ADR because they both have the interlink together. High Court has rules and orders where commercial matters can be decided, and like our full bench, full court recommended for 3 extra commercial benches, but I recommended that there will be a full-time commercial judge for a full-time one day because London Commercial Court have 12 judges from the High Court which are sitting in Rose Building mentioning things because they are full-time mentoring the matters. Then we have the ordinance, the PISA judgment has some truth. Next, please. Last slide. I have 2 minutes now. This is the international arbitration. Next. As Shiraz just mentioned, on the Chief Justice Pakistan, Justice Muhtar Bandial, when participated in International Arbitration Conference in May 2022, when the CIRB was launching their branch office here, where they supported the Lahore Declaration, and the outcome of the Lahore Declaration is that they are now training the mediator at the Federal Judicial Academy from Monday onwards. Then Justice Shah and I myself, we were in London, speaking at King's College, raising on the international arbitrations and the confidence to investor, where we talked about a new Center for International Arbitration like others. We spoke about the international, revising the new law because Pakistan Arbitration Act needed an update because the Supreme Court judgment. And also, we can take the example of the neighboring countries, the New Delhi International Arbitration Center, Astana is in Kazakhstan, in Dubai, Tehran, in China. World is now looking totally in the new trend of commercial courts within the high courts, full-time judges, and that is what I wanted to share with you. Good news, and good news. And that is, at the end, I say that we're thankful to the Law Justice Commission for giving this opportunity. And I'm leaving those booklets of the Lahore commercial courts and the judgments and the articles are written on that, and also on the overseas cell for the reference. And anybody wants any copy, they can ask my registrar at the Halkar, and we can provide them. Thank you.
Thank you, Justice Jawad Hassan, for updating us about the progress made by the Lahore High Court in the field of commercial arbitration and setting up commercial courts. I'm sure the other high courts would like to emulate that example. You've also given us a resume of the judgments delivered by various high courts as well as the Supreme Court of Pakistan, which would increase and go a long way in increasing the investor confidence in our judicial systems. You have also told us about how ADR is being encouraged and supported by the judiciary in Pakistan, which is an ongoing progress, which is a work in progress, and we are committed to doing so. Now, there are some questions for the panel. This first question is from Mr. A.R. Aurangzeb, President, High Court Bar Association, Bahawalpur. And his question is, under Section 89A CPC, ADR plays its role when both parties give their consent. Is there any way or solution to compel the parties to join ADR by the authority of the court and without seeking their consent? And I guess this question is addressed to Justice Jawad Hassan.
There's no need to compel any party, because if the matter is arbitrable, and that can only be determined through the agreement between parties, and that has the sanctity as per the judgment of the Supreme Court of Pakistan. The change of judgments, so once the parties are agreed under the dispute mechanism, then the parties are bound to go for the arbitration with the intervention of the courts or without the intervention of the courts. So that is depending on the agreement. No arbitration can be referred by any court forcefully when there is no arbitration matter. It can be mediation, it can be reconciliation, it can be a settlement, but no arbitration.
I would like to add to that mediation especially is, would you switch on? Mediation especially under the present law and under the present statutory law, it is by consent only. But there are efforts where mandatory mediation is under consideration, where even if a party goes to the court stays its hand and gives a specific time frame within which they have to go to mediation, and in case mediation doesn't succeed, then they get a certificate from the mediation center and come back to the court after a certification that bona fide efforts were made to resolve the dispute through mediation, but the mediation did not succeed. So yes, there are things in the pipeline, and you may see some statutory framework where the courts could compel the parties initially to seek mediation, and in case the mediation does not succeed, then obviously the doors of justice and the doors of courts cannot be shut on them. I hope that answers your question. Okay, the second question is from Mr. Tajammul Shahzad Chaudhry, who is the Additional Sessions Judge, Gujranwala. And the question is directed towards Mrs. Justice Patel. The question is there any time limit or time constraint for resolution of a dispute that is referred to court-annexed mediation in your country? If yes, what is that time frame?
Session Chair, I take it you can still all hear me?
Yes,
we can hear you.
Thank you. To answer that question, according to the rules that we have established in Zambia, there are certain timeframes that have been allocated for cases that are referred to mediation. For example, the rules in the commercial division of the High Court mandate that a mediation must be concluded within 30 days. In the general list, which is our general division of the High Court, the time frame for compliance is 45 days. And the problem that comes, and this is why I say that we need stakeholder participation at various levels. The problem that emanates out of these time limits is you need a proactive judiciary, you need a proactive mediation office such that records don't get lost in the system of ADR, and you need stakeholder buy-in from the bar, from the members of the bar, so that they can actually encourage their clients to attempt a court-ordered mediation. But there are definite timeframes that have been allocated by the various courts, and we try to enforce those. If parties come back, what I routinely do in my court, and I head the commercial division, is I will, at the time of
Mrs. Justice Patel, there is some problem with your connection, if you can hear me. We can see and hear Mr. Ravi just fine, but there's some problem with the connection at your end. Would you be so kind as to refresh it if you can hear me? Your Lordship, maybe we can come back and refresh this. No, you don't.
Well, obviously there is some technical hitch in the internet connection. But before I conclude, I believe we have devised the following recommendations as a way forward. Number one, assessing global trends and working methodologies adopted for effectively using ADR in domestic and international settings. Number two, encouraging court-annexed and court-endorsed ADR, including through arbitration, mediation, conciliation through the courts. Number three, developing focused and harmonized legal and implementation frameworks for governing ADR. Number four, capacity building of stakeholders involved in the ADR processes, which must be ensured. Number five, adopting efficient and fast-paced out-of-court settlement and dispute resolution mechanisms by taking all stakeholders on board for ensuring investor confidence. Number six, encouraging ownership of ADR by the judiciary of Pakistan. Number seven, encouraging adoption of ADR by lawyers and litigants alike by raising awareness, conducting trainings, and setting up ADR centers. And following innovative trends across the world, including use of technology.
That concludes the session regarding alternative dispute resolution and the commercial aspects of law. Thank you very much, Your Lordship, and the respected participants, and especially those joining us from cross jurisdictions. Thank you very much.
And a good round of applause for all the panelists and experts. Thank you very much. Thank you, Saad. You did a great job. You conducted this session very well. I'm sure others were also conducted as well. Thank you very much, all.
May I now invite my colleague Haider Waheed Saab back to stage once again. He'd be introducing and conducting the next session. Thank you.
So upwards and onwards to session 5, which is justice and digital advancement, and what lies ahead. Before I can invite the Honorable Chair up on the stage along with the panelists, I'd just like to cite to this particular judgment of the Honorable Supreme Court that I think lays the groundwork for this particular session. In this judgment, one of Sindh High Court's very best, Mr. Justice Muhammad Ali Mazhar, who's also on the organizing committee here, in a judgment authored by him, he holds and writes as follows: The law must not become stagnant or archaic while society moves forward. It must be accessible, intelligible, and must change with the times, responding to the realism of modern day life, which requires transfiguration of new ways and means an invention of up-to-date mechanisms for the purpose of providing access to justice with the aim to cut down the volume of litigation and pendency of cases. Certainly, we are gathered here today to bring to the doorstep of the public justice. That is what dispensation of justice is all about. If I can have the honor of inviting the Honorable Chair of this session, Mr. Justice Jamal Khan Mandokhel, who has been very kind to step in almost at the last minute because Honorable Justice, Mr. Justice Munib Akhtar, could not attend this session. We are grateful to you, Mr. Jamal Khan Mandokhel, Honorable Judge of the Supreme Court of Pakistan. Honorable Chair, with your permission, I would just call on stage the panelists that will be joining you for this session. If I can have the honor of inviting Mr. Justice Babar Sattar of the Islamabad High Court. We are indeed privileged to have him. For most of us, he may have been lost because he was also one of the finest writers. But thankfully for lawyers and us in our system, we keep reading his judgments. Mr. Mohammad Zafar, who is going to talk about cyber crimes in Pakistan, challenges and the way forward. He is an officer of the Police Service of Pakistan, if I can invite him on stage. We are also happy to introduce 3 members of the panel that will be joining us online. Judge Paul Kwan is with us. He will be speaking on justice in the new digital era, digitalization of the courts and its challenges. Can you hear me, Mr. Kwan? Justice Kwan?
Yes, I can, loud and clear.
Thank you very much for joining us. We are also joined by Dr. Francisco T. Elizalde, who I believe has also joined us. A very warm welcome to you, sir.
Thank you. Good afternoon.
Mr. Jeffrey Apperson will be completing this panel. He will be speaking on the global best practices for case management and tackling the backlog. Okay. Over to you, Honorable Chair.
Bismillahirrahmanirrahim. I'm thankful to all of you, the August gathering, that you are participating in the conference in such a large number, especially at this time of the day after lunch. You have heard speeches of a number of speakers. Some of them are very good speeches, but I am not as good a speaker like others, especially Justice Athar Minallah, with whom I principally agree, but I can't speak like him. The time is granted to me by the organizing committee. I'm grateful to them if they have proposed a confidence in me. The topic assigned to me is the justice and digital advancement. The Judicial Conference provides us an opportunity to highlight the problems being faced by the judiciary and to share experiences that can be taken towards digital advancement of the betterment of the judicial system. In this session, the speakers will discuss the importance and proposed steps for the digital advancement of judicial system in Pakistan. The topic is justice and digital advancement. So justice, the word justice should not be limited only to the judiciary. In my opinion, every person is bound to deliver justice. he must start from his house to deliver justice with his children, to deliver justice to his family, and every person connected with the affairs of the federation, the province, or the local authority is bound to deliver justice. The judiciary comes subsequently when injustice is done in the society. So, justice is the responsibility of every citizen, may he be in the judicial capacity or in his personal capacity. So therefore, digitalization of the institution is utmost important to achieve the goal of justice delivery. In my opinion, this is the most important topic assigned to me, because in all the previous sessions, I think digitalization will play a pivotal role for advancement of justice. Digital advancement will prove as the key to making justice system efficient, cost-effective, available to all, and will also keep helpful in quick disposal of cases. Everyone nowadays is talking about backlog of cases in courts and is also anxious about disposal of the same. There may be suggestions for quick disposal of cases, but I have not heard about causes of pendency of cases. I have not heard from anybody about causes of pendency of large number of cases. In my opinion, one of the major cause is the increase in number of institution of cases. One of the reasons of the increase in the institution of the cases is non-digitalization of the land record and the manual system of investigation. It is important to mention here that I will give example of Balochistan, where more than 90% land is unrecorded. There is no land record in 90% of Balochistan. So when there is no land, no record, naturally the people will dispute their rights, the rights of others, and they will then approach the court, which will culminate into increase in the pendency of cases and will also culminate into criminal litigation. So because of one dispute, the court is burdened with two cases, one criminal and one civil. If the land record is digitalized, I hope that the right of the people will be secure, the right which is guaranteed to the people of Pakistan by the Constitution. So it is therefore very important to have every department digitalized. Same is the situation in the FATA and PATA, which is now merged into the province of Khyber Pakhtunkhwa, where also the land is still unrecorded. So this non-digitalization of land is one of the major cause of rise of land disputes between the parties. Taking advantage of this conference, it is high time for the federal and all the provincial governments to take immediate steps for digitalization of land record, which will ultimately result in decrease in institution of fresh cases. Similarly, the use of modern devices and digital technology in criminal investigation and for procurement of evidence and court proceedings, it will certainly help in reducing the backlog and will result in expeditious and cost-effective litigation. Though the courts in Pakistan are using digital technology and cases are being heard in this court, in the Supreme Court, regularly through video link from branch registries of all the 4 provinces, But still, much more is required to be done for maximum use of digital technology in courts. Here, I must appreciate the Honorable Chief Justice of Balochistan High Court, who has started video access to the branch registry of Balochistan in Sibi. The Judicial Conference provides us and to all the stakeholders to get benefit from the experiences and expertise of the participants of this session, which will sensitize the authorities concerned to take steps towards the digital advancement of the judicial system in Pakistan. I appreciate the efforts of the organizing committee and the Secretary of Law and Justice Commission of Pakistan by organizing organizing this conference successfully. And Judicial Commission, the Law and Justice Commission can play a pivotal role in this behalf for the digitalization of institutions and record of the case. I once again thank you, all of you. At this time of the day, after lunch, it is very difficult to hear speeches like one of mine. I am grateful of you and hand over the mic to my thank you very much.
Since the Honorable Chair has delegated this responsibility, I'd like to invite Mr. Justice Babar Sattar to address the audience.
Thank you very much. I'm very grateful to the Law Commission for inviting me over. Slides चलाएंगे ज़रा presentation. So when I was asked to speak on free speech and social media, I kept thinking to myself, what is it that we're trying to regulate here? And what is the problem that we're trying to solve? And I've asked some of the more intelligent people that I know, and there was no coherent answer other than the fact that there is a lot of fake news now. And that is what we need to regulate social media for. So keeping that in view, next slide, please. Before we get into the social media, next slide, please. This is the broad outline of what I'll speak about. The constitutional framework very quickly, the right to freedom of speech, the constraints on free speech, and I've been accused of being on the liberal side of political ideology, and I'll confess that I probably am. I think there should be less control of the government in the lives of ordinary people. And then the question is, who controls social media now? How do we hold the big tech to account? And what are Pakistan's choices, given that we don't host any of these big tech companies that we use here? Next slide, please. So let me run through the constitutional framework quickly, because I think we're all in this room fairly familiar with it. Article 4, Justice Jawad Hassan spoke about it. It kind of clarifies that the state can only interfere where there is a legal right for the state to interfere, or where some law gives it the authority to interfere. Citizen, on the other hand, is free to do whatever. So that's the big difference between the government, the state, and the citizen. So the concept of liberty is kind of built in Article 4. And then the concept of the right to liberty is expressly mentioned in Article 9 of our Constitution, right next to life. We have very limited jurisprudence on the question of liberty in this country. And I hope that there's going to be a lot more of that, because without your right to liberty, life can be pretty meaningless. Then there is the right to dignity and freedom of conscience. And then there is the freedom of speech and freedom of information under Article 19 and 19A. And these two articles, the right to free speech is an ancillary right in a sense that it's not that you're going to just express yourself, but by expressing yourself, you actually claim the other rights that you have, including the right to dignity, the right to a conscience. And if we look at the statutory laws that we have, Article 19 is not does not create an unconditional right to speech, and it creates a lot of unprotected speech. And then we have a lot of laws, unfortunately, in my view, as a student of law, which curtail speech. And I've put down a list of some of them. We've criminalized speech in the Pakistan Penal Code. Now we have the Pakistan Electronic Crimes Act as well, which kind of puts in Article 19 verbatim. And what that is doing is that's kind of given the authority from the Constitution into a statute all the way down to some official, maybe within the regulator, who will be making choices as to what speech to allow and what speech not to allow, and doesn't really create a judicially enforceable standard to determine where speech is to be curtailed. There are rules that have been framed under Section 37 of PICA. Those are presently under challenge at the Islamabad High Court, so I'll not speak about them or their sufficiency. Next slide, please. Within our constitutional framework, not very different from other common law jurisdictions, the law was laid down as far back as 1958 in East and West Steamship Company, that the means that the state will adopt to regulate fundamental rights should be least restrictive and very narrowly tailored to attain the objective of the state. So the constraint has to be least restrictive of fundamental right, including the right to speech. This is good law. It's been cited in other Supreme Court judgments as well. Next slide, please. Some of the most robust freedom of speech jurisprudence has come out in the US because the constitutional provision upholding free speech is a lot clearer. But these are the two tests that I wanted to flag because they are relevant for how we think of the social media as well. So in Schneck, the clear and present danger test was laid out, that it's only where speech is creating a clear and present danger will you deem it appropriate to actually interfere with the right of someone to speak. And then there is the whole idea which we are grappling with in the context of social media as to what to do with fake news. And again, I think it was Holmes and Abrams who came up with the idea or articulated the idea of a marketplace of ideas. We know there is bad speech. What do we do with it? You create good speech. And the idea is that if there's enough of it, the good speech will ultimately drown out the bad speech, or sensible people in the society will be able to figure out that, okay, this is bad speech because it can be compared with good speech. Next slide, please. So some of the basics, some say there is nothing such as free speech. Every society will impose constraints. The other view is that there's always the right to speak freely, but then there are consequences. So what are the consequences? States will put legal penalties. We've talked about some of the laws in Pakistan that put these penalties. Then there is social opprobrium. If I say something silly here, I fear that my peers and all of you will judge me. So that is something that applies constraint on how we speak. I've already mentioned that speech is an ancillary right, and it is important to uphold it because without it, you cannot exercise some of the other rights: liberty, dignity, democracy, democratic, political speech. And the restraint on speech, again, it is to essentially prevent harm, to protect privacy, security, and create democratic equality. Those are some of the values or concerns which lead us to then try and regulate speech. Next slide, please. So I quite enjoyed Liberty when I read it for the first time, and I think J.S. Mill very correctly points out that you only interfere in a free society with somebody's fundamental rights when the exercise of those rights will create harm for somebody else. So that's the harm principle when it comes to enjoying fundamental rights. And in this context, most of the debate has been around speech critical of the government or state institutions. And in a democratic society, people are free to criticize the government and state institutions. So in developed democratic societies, that kind of political criticism is protected. There is wide berth given to critical speech. Now, nobody likes criticism, we understand that. Somebody criticizes us in our personal lives, we don't like it. People take offense to things, but notwithstanding that it might be offensive, there is need to distinguish between offensive and harmful and threatening speech. And that's a debate we sometimes lose track of here in our country as well. Then there is speech which is harmful to vulnerable segments of the society. There, the judiciary obviously has a role to undertake strict scrutiny and ensure that no harm comes to somebody else. Even in terms of political speech, to the extent that there can be incitement, there is time, place, and manner regulation. But the whole idea in 2022 that speech can just be banned because it is critical or it'll upset somebody who's very powerful is quite alien. But we still see that argument being made here. Next slide, please. So free speech, and I think these principles will have to be borne in mind when we think of social media as well. There is the whole idea of paternalism, which disregards human agency. All of us are adults. Those of us who are, we are free to choose what to hear. And when it comes, especially when it comes through social media, nobody is forcing you to go onto the internet and join a social platform and hear X, Y, and Z. That's a choice that people make. And to the extent that they bump into material that they then find offensive, what is the problem there? You can cut it out. Choose not to access such speech. Then there is the whole question of moralistic regulation of speech. Can that ever be? Because morality and dignity are also two words that Article 19 uses. How do you actually regulate morality in a society? Or how do you set the standards of decency other than if it is set by the parliament, because there are people's representatives there? Sometimes it is judges who got to make these choices, and I, at least now for the last 2 years as a judge, feel extremely unequipped to make moral choices for other people, because there is no way to do it other than your own subjective understanding of the truth, reality, religion, etc., and your own family values. So I think at some point we might actually need to go back into the Constitution. The Parliament probably should look at Article 19, look at morality and decency, and whether or not it is the state's job to actually enforce some of those standards, which will differ from one person to another. Then you think about why people have been afraid of loudspeakers or technology or even the printing press. Because every time technology comes in, it creates a certain fear that you're not going to be able to control things. And we like to control things. And that's where the whole idea of censorship, if we study the history of censorship, that also comes in. Next slide, please. So I think there is a moral panic right now. Social media has made it very easy for people to speak and express themselves. And the states especially, and even the more powerful in the society, don't know what to do with it. Is social media different from other mediums? Yes, it is. It is different because of the sheer volume of speech. Newspapers, public gatherings, etc., requires cost, time, etc. When you're sitting on Facebook or Twitter or any of these YouTube, these platforms, it's very easy to speak. So that's created a lot of volume, and it's also brought in anonymity. So those are the two problems that we need to think about. In regulating social media companies, there can be a policy declaration by the state through law as to what will be the contours of regulation of social media, without actually getting into the day-to-day regulation of content on social media, which I'll submit is not possible It's not going to be possible, no matter how hard we try. Social media companies have their own policies for regulation of content. There should be a disclosure of that. There should be a mechanism for grievance redressal. If your account is shut down by Facebook or Twitter or YouTube, there should be a mechanism. Individuals need to be given more access. If I am a user of social media, I should have more control over what kind of content I access and what is it that I don't want to see. Social media companies should be encouraged to do some of that. But it is not for social media companies, again, to fact check each and everything, because people are producing content. It's simply not possible for a company to go in and say, okay, this is correct information or this is incorrect, unless the account is huge. If something is coming from the president of a country or an official account, maybe. Next slide, please. So in terms of free speech and social media, social opprobrium works differently on social media because there is anonymity, which gives shelter. Justice Harlan, in one of the judgments that he gave out in the US, talked about averting the eyes in a public square if you bump into something which is offensive. So I think we will have to understand that what is offensive is not illegal necessarily. Just because your neighbor is standing across and making faces at you, which might offend you, doesn't mean that you have a right to shut it down or shut him or her down. So there'll have to be some thickening of our skins, because it's easy for people to know what other people are thinking of them now. People, I'm sure, at all times had thoughts about other people, but now they can express them and you can access them. Will that offend you? Yes, it will. But we just have to learn to live with it, is going to be my submission. Social media is not like a newspaper. It doesn't regulate content. It doesn't have an editorial team, but it is beginning to employ editorial teams to figure out what is it that should go on and what is it that shouldn't be there, because there are some genuine threats. There is terrorism, there is intimidation, there is incitement, there is child pornography. So there are vulnerable segments in the society that still need to be protected, and for that, some mechanism. Is that mechanism going to be somebody sitting there and figuring out every tweet, every Facebook post? Maybe it's happening right now. Ultimately, it's going to be artificial intelligence that will undertake analysis of metadata and probably have broad filters. Now, it'll take some of the objectivity out, but you can also write that objectivity into those codes that you're writing. So I think that is a place where the policymakers and the parliament will have to step in, because one of the bigger debates, next slide please, one of the bigger debates in the US and the West right now is, can the role of censorship be given to private companies? Because there are 5-6 private companies on the West Coast. They are regulating most of the content. Fine, we might like our Zuckerbergs and all of them right now, but what if that ownership was with different people that we didn't like? What happens then? So there is a larger debate that within social media, the contours of what social media companies can do in terms of regulating content on their own platforms has to be regulated by law. Now, in my view, that should be a very broad regulation, because otherwise there will be chilling effect. And it will not be possible for the state to then go in and actually try and weed out each and every offensive tweet or Facebook entry. And there are competing concerns here. Competition, obviously, between social media platforms, privacy and security. If you give too much privacy, then what do you do with somebody who's trying to create a terror plot, or somebody engaging with child pornography, for example? But if you look too much into the issue of security, you're going to go in and read each and every social media post that people write, and that's going to undermine their privacy. So there is this balance that will have to be struck. Societies will do it differently, but the tendency generally that we've seen in Pakistan has been to over-regulate. We get offended. If somebody gets offended by, let's assume, Facebook is shut down. Somebody gets offended by TikTok is shut down. I think this way of thinking of social media regulation in this day and age is quite unbelievable, because there is also the right to freedom of information that comes with control and regulation of social media companies. A lot of the people are getting their information from Facebooks and Twitters and YouTubes as their first line. At some point it was the radio, now it is social media companies. So, next slide, please. There are no elegant solutions. The suggestions that I can possibly make is that there are certain policy choices in terms of balancing of competing values. Those policy choices must be made by Parliament. The agency, in our case is the Pakistan Telecommunication Authority, would have some role, but it should have a very high-level role, and there should be no calls made to social media platforms and companies to shut down this tweet or that tweet or this post or that post, because that's not going to work. We cannot fight technology. We've got to accept what's out there, and we've got to grow slightly thicker skins. There should be no legal paternalism. Grown-ups don't need to be told that they don't know wherein their true interest lies. If they have the freedom to hurt themselves or bump into offensive material, it's a choice they're making, and they're grown-ups to be able to deal with the consequences of those choices. There should be a big no to viewpoint censorship. Every time as courts we see, every time there's a change in the power corridors, there's a whole set of cases that come rushing in, and it's got to do with viewpoint censorship. People get offended by what and the cycle goes on and on. At some point, I think, as a polity, we'll have to figure out that this is not the way. Last slide. Next slide, please. I think just a word on Pakistan's choices. Pakistan is on the receiving end. We're a smaller country. We don't host any of the big social media companies. We have to engage. Our ability to influence the policy of social media companies will only grow if the social media companies feel secure and safe by the regulatory environment, find our environment inviting enough to be here. If they're here, we might have some influence. If they're on the West Coast, we have no influence. All we can do is shut down a whole platform, and that only makes us look silly. So yes, acknowledging reality and not fighting technology. There is deliberateness to social media. Let's just get used to it. There is the propensity of the state to overstate the case of security. We've seen that all of our lives. I think there is need for both policymakers and the judiciary to take a correct measure of what is really that we're trying to do when we say we want to regulate social media. What is the concern? If the concern is hateful speech, yes, let's talk of algorithms, let's talk of filtering methods. But if the concern is that people who are powerful are going to be offended and are offended by what is written by ordinary people, that's just how democracy works. So I think a lot more emphasis on liberty, a lot more emphasis on agency than we presently have. Thank you so much.
Thank you, Babar Sadar. I hope that the legislature will take advantage of your suggestions. And as far as the judiciary is concerned, we are looking forward for you to deliver an authoritative judgment in this behalf.
Yes. Very grateful to you, Justice Babar Sattar. A very delicate topic indeed, with all the fake news flying about, but you took a long-term view of it, about how constitutional rights need to be balanced, and a long-term view should be taken about regulating fundamental rights. I will now, with sincere apologies to our foreign guests, call upon Judge Paul Kwan to be our next speaker. Judge Paul Kwan is the Executive Director of the Singapore Judicial College. He was appointed District Judge of the Republic of Singapore on the 1st of June 2009, and he will be speaking on justice in the new digital era, digitalization of the courts and its challenges.
Thank you very much, Mr. Haider. And just so that I'm going to do a sound check, can you hear me loud and clear?
Yes, you are.
Yes,
you are.
absolutely.
Fantastic,
We can hear you.
fantastic. And just so that you can enjoy my presentation, can I just trouble you to just spotlight me for the entire duration of my session, because my presentation, as you can see, is right behind me.
Yes, please.
So thank you so much, Judge, for that very first session. And I also want to thank Mr. Justice Mandukil for his opening remarks. So a very good afternoon, Honorable Chief Justice of Pakistan, Honorable Judges of the Supreme Court, Honorable Chief Justices of the High Courts and Supreme Court of Azad Jamal and Kashmir, Honorable Acting Judge, Chief Judge of the Supreme Appellate Court of Gilgit-Baltistan, judges of the Federal Shariat Court and High Courts, judicial officers from across Pakistan, Madam Secretary of the Law and Justice Commission of Pakistan, members of the legal fraternity in Pakistan, ladies and gentlemen. I'm Judge Paul Kwan. I'm the Executive Director of the Singapore Judicial College. I'm indeed very honored to address such an august audience, and I'm deeply humbled by the generous invitation extended by the Commission to do so on the occasion of Pakistan's 75th year of independence. May I also take this opportunity to express our thoughts and prayers are with you and your people affected by the floods. It is tremendously difficult to speak after a judge's really splendid presentation, and when one is on such a distinguished panel with judicial and domain experts from at least 3 jurisdictions. On this occasion, I'm particularly pleased to make new friends and reunite with old ones, including Deputy Secretary Abdul Basit from the Commission and Vice President Jeffrey Epperson from the U.S. National Center for State Courts. I shall humbly attempt to provide some food for thought on the topic that I've been asked to speak on, and that is the challenges of digitalization for the judiciary in a brave new digital world. The question that this session poses, what next, does not exist in a vacuum. We have to understand the context that will inform our thinking. And as this conference aptly suggests, how we do this is we should look back, we should reflect, and we should consolidate before looking forward. We recall that when we were outside the woods, so to say, before the pandemic, technology was playing pretty much a handmaiden role until we were neck deep in the woods, where technology morphed and took on a more important role, and it became a really must-have overnight, driven by the sheer need of necessity. Now that we have emerged from the pandemic, we have the luxury of asking, what next? Do we and can we return to the status quo ante pre-pandemic, or have we actually crossed the Rubicon? That backdrop or context is in turn informed by how much the justice gap was narrowed because of technology. If technology was a great leveler during the greatest black swan event that we have experienced in recent times, then the judiciary would have entered the golden age of accelerated technology adoption by decades. Narrowing the justice gap goes beyond remote hearings, remote judges, remote witnesses, and remote lawyers. And here I wish to highlight 3 aspects of the justice gap: the physical, the literacy, and the resource aspects of the gap. First, No one can doubt that technology has actually narrowed the physical aspect of the justice gap by bringing the courts closer to the people, by allowing them to interact with the courts from the familiar environments of their offices, their warehouses, their homes, or even on the go in the car. As for the literacy aspect of the gap, these days anyone can educate himself or herself on almost just about everything on the internet, including the law. The fact that this conference is beamed live over Facebook attests to that fact. And finally, the resource aspect of the gap speaks to new alternative legal service providers, and some even say less alternative now because they are recognized alongside mainstream providers entering the legal services market sector. If your experience, therefore, was that technology showed promise to bridge this justice gap, you would say that technology is an enabler, and to which I will respond to say we will then therefore have to leverage upon it as an effective conduit. If you have a less positive experience and you say that technology is a barrier which interposes itself between the court and our constituents, then I say to you, we have to bridge it. So in essence, I'm responding and I'm appealing to both sides of the cap. Singapore's experience have been generally positive, and we are riding the waves instead of being swept away because we keep an eye on two things while adopting technology. The first is that we ensure that the integrity of the process is not unwittingly undermined by technology. And second, even in a remote setting, we ensure that evidence continues to be properly assessed. For us, remote hearings are now part and parcel of our court landscape. And we can't put the genie back into the bottle because we have made such tremendous progress in narrowing the justice gap that it just doesn't make sense to walk back on all the progress we have made these last couple of years, which would otherwise have taken us years and decades to accomplish. In relation to the use of technology, we want to ensure that what we deliver through technology is fair and that technology does not impede access to justice. And we do this by acknowledging the digital gap, acknowledging that it is real, and to bridge that gap. To realize the full potential of technology, we have to go more than porting physical courts online or go beyond automation, as Professor Richard Susskind has suggested. What we actually need to do is to implicate the entire court or justice ecosystem. And what I mean by that is this: we do not just merely graft technology onto existing systems or frameworks. Rather, we think about how to design from the ground up with technology weaved into and driving those very systems and frameworks. Time permits me to only highlight two ways in which the Singapore courts are striving to do this. And we are still very much learning from everyone else, but I will just highlight two developments for your consideration. The first is asynchronous hearings. And asynchronous hearings in Singapore are actually paper hearings without the need for parties' attendance or oral hearings, and with the exchange of electronic messages between parties and the court. Now, in order to understand this and to wrap your mind around this, just think of WhatsApp on steroids that is integrated into an electronic filing service, and there you go. That is your asynchronous hearings in Singapore. And we found that this was a much more efficient use of time because it does not demand that everyone does something at the same time as traditional synchronous hearings does, which means that time can be parceled out and generally there will be a more efficient use of time. Second, as some of the speakers have already alluded to, the blue ocean territory of online dispute resolution. And in Singapore, we have two aspects of this. One is called e-negotiation, and the second, e-mediation. In these processes, they are completely administrative process, leaving the courts and the judicial system right out of it without our intervention, where parties can attempt to make offers and counter-offers to try and settle the dispute through electronic negotiations. And failing which, they can then enter a chat room and call the judge to help to mediate through the e-mediation module. The technology is modeled after text messaging, which parties use in everyday lives and are familiar with. I come back to where I began, and it is this. Have we crossed the Rubicon? And I suggest that for most courts, we are crossing it at the very least, and it holds a pathway for change. But make no mistake, because technology can either be a gatherer or it can be a scatterer. Honorable Chief Justice and Justice Mandukil, I suggest that the lodestar continues to be our constituents and the people whom we serve. We should never lose sight of looking at this from the perspective of our court users. And if I may respectfully echo the eloquent words that were uttered by the Honorable Chief Justice of Pakistan yesterday evening, we should not fall short in the balance of justice. We need to begin to recognize alternative notions of looking at courts as a place from the perspective of their users, and to seize this opportunity to adopt innovative technology that works for the people whom they serve, that is both fair and provides access to justice. If that is the change that our courts embrace, then we would be all the better for this, and we would not let the side down. So once again, let me say how grateful I am to be able to speak with you this afternoon. I'm very much looking forward to our discussions later. Honorable Chief Justice, my Chief Justice has also asked me to convey his warmest regards to you, your Lordship, and your colleagues on the bench. Thank you very much.
Thank you, Mr. Paul. And your experience and the model of your country will help us in digitalizing our institution, especially the judiciary. Thank you very much, and pay my thanks to your Chief Justice as well.
Thank you. Thank you very much.
Thank you, Judge Kwan. Next, we have Dr. Francisco de Elizalde. He will be speaking on the use of technology in courts and the legal profession from a lawyer's perspective. Mr. Elizalde is a full-time professor at IE University and founding director of the legal clinic there. Mr. Elizalde.
Thank you. Good afternoon. I don't know if you hear me well. Thank you, everyone. Thank you, the Honorable Chief Justice of Pakistan for the... Do you hear me well?
Yes, welcome. Welcome, Mr. Francis.
Good. So the sound is good?
Yes, yes, it is good. We are hearing you.
Thank you. Thank you. So I thank the Honorable Chief Justice of Pakistan for the invitation. Good afternoon, Honorable Chief Justices, justices, dear members of the audience, and dear colleagues. It is very difficult to speak after Judge Kwon's amazing presentation. I will try to cope with that, but making my presentation shorter. In the sense, it's very difficult to compete with that, and I congratulate you with that. So I will follow from where Judge Kwon stopped probably, which is the move or possibilities of moving from digitalization to automation. And I will giving probably more academic, but also a lawyer's perspective on this. I'm currently director to a Center for Law and Automation, where we are exploring possibilities of judicial decisions to be automated and the role that both technology and law has that. I will not have the time to delve into main rights of the parties that are being subject to those decisions. I will simply explore those possibilities. So I have a presentation, brief presentation to share. I think I saw it in the screen over there. If not, I can share my own screen.
Yes, it is on screen, yes.
Great, thank you. So very briefly, I will, the idea, if I can pass to the next slide. The idea is to present very briefly what could drive that move to automation of certain claims. I will present a survey that I led and we conducted to the so-called legal tech companies in litigation throughout the main European legal market. And then I will give some indications on the law as such and its importance for automation. So if we can move to the next slide, please. So in terms of automation or moving to digitalization as well, in terms of also ODR, online dispute resolution mechanisms, there is a usual assumptions that the digital environment is is better for small value claims. Okay, so we say small value claims are the ones that should be digitalized, and let's leave the big and important claims for normal justice. Okay, this has received many criticisms, especially in terms of equality in front of the administration of justice, saying why should big claims be the sole concern? But it's true that in many European legislations, many European jurisdictions, small claims are taking a big workload of courts, causing sometimes backlogs. So it's important to address them. But the assumption that is made that this is the path is something that I want to challenge. I want to give a different perspective. I don't think that the amount of claims is what is important, but how the law is drafted. And this is how in the next slide is where you can move to it, is what I call technological efficiency. Okay, so this is a characteristic of the law that defines whether it's apt to interact with technology and in the sense with automation, requiring less human intervention. Okay, so my claim here is that the law is what determines whether automation will be successful or not the value of claims. And in the law, of course, it's important how the law is drafted and how the law is interpreted by judicial decisions. Okay, so we can move to the next slide. So here, this was, as I was telling you, there are lots of companies that in the absence of automation and in the absence of advanced digitalization of European courts have resorted to private solution of claims by these so-called legal tech companies. These companies automate both the assessment of the claim without lawyers, and they assess thousands of claims, and the AI systems are able to determine the amounts that correspond to the affected party. This has had an redress of claims that were normally left out of the legal system, but at a high cost. Okay, so these companies charge high success fees, which could hinder the rights of those affected. So it could be a good move that these technologies have been proved successful by private companies solving litigation claims are adopted by courts and made available to all the citizens. So if we can move to the next slide, I will present very briefly the results of this. So if you see from this graph, you see a blue big area of the results, which means that most of these litigation companies in Germany, in the UK, in France, in Italy, and Spain, which are the 5 largest markets for legal services, most companies deal with airline claims. Okay, so as litigators, as judges, you know that the facts of the case will determine the applicable law, and here the facts are flights that are cancelled, flights that are delayed, and the substrat, the applicable law in Europe for that is the European Flight Compensation Regulation that applies equally throughout the European Union. So in the next slide, we'll try to see is why do these results occur? Why do companies choose this law to prescind of lawyers and move away from courts? And if you analyze the technology that they use, well, all types of technology has been used, from very traditional coding to sophisticated use of artificial intelligence, for example, in the form of natural language processing that allows automatically to assess cases and determine how they should be solved. Okay? So in the next slides, what I try to say is that the relationship between the law and technology and the law and automation of claims is direct, in the sense that the more the investment, the more sophisticated investment, the better the results that you will achieve in automation, which is something intuitive. But probably counterintuitively, that relationship is not proportional. So from the survey, we detected that there are companies with very sophisticated technologies, and also the same company with the same technologies, but depending on the type of claim, they were able to automate those claims to a larger extent or not, which means that with the same technology, you don't achieve the same results. So that's why in the following slide, what I say is that the law is important in that automation. If you can move it to the next slide, please. The law is very relevant in automation. The applicable law to a case could determine automation. And this has allowed us to let's go to where you were. This has allowed us to classify those companies followed in the survey from high level to low level automation. What does high level mean in this case? Is that the AI systems were able to determine whether the client had a plausible claim, okay, whether the claim was successful according and based on case law and based on the applicable law without the intervention of lawyers, okay? And on the other extreme, whether, and also to determine the amounts that were due. And we were focusing on civil claims, okay? On the other extreme are those companies that can do none of those, okay? And in the middle, of course, medium high, those ones that do the most difficult task, which is assessing the plausibility of the claim, and medium low, which are not able to do that without lawyers, but at least can determine the compensation that is due. Okay? So based on that, in the next slide, we see how these companies from this survey were classified. And we see on the high extreme that claims dealing with airlines complaints, with banking complaints, to which a European instrument applies, the European Unfair Terms Directive, and tenancy complaints in Germany. And this is particular to Germany because they have certain price caps in certain cities, which is also a way that works well with artificial intelligence to determine the plausibility of claims. On the lower extreme, we see, for example, general claims platforms, those that deal with all types of claims. So once again, it seems that when the claim is determined and certain claims are determined, automation is more plausible. So in the next slide, please. The question is the same as the beginning, are legal rules that are better suited for automation than others? And from this service and also from some experiments that the Direct Center that I direct with the general support of the European Commission are testing, is that how the law is drafted is key for automation. And this would be important for dispute resolution, ADR, ODR, but it's also important if we want to ease courts from certain claims that could be massive and that could be causing backlog in the system. So in the next slide, please. I very briefly, the survey also asked participants a question, an important question is, what do you think about standardization of law? You know that, think for example of how automation probably was fostered in the 19th century with the Ford system, of producing cars, moving from less manual labor to more automated or robotic ways. You can think of standardization, the same processes that are done multiple times. Okay? And the hypothesis that this can also be applied to laws. We can think of laws that are more individualized, that need a more case-by-case assessment, and laws that are more standardized, that are applicable with more similarity to a number of cases. And these companies, the ones that have developed the artificial intelligence, once again, in the absence of the European court doing so, when they were asked about the importance of that characteristic of law being some more or less homogeneous or standardized, more than 90% said that it was either essential or very important in their legal tech models for litigation. So in that next slide, please, we'll try to see with just one example is the example of airlines. Is how do we see this standardized characteristic in airlines? With my idea of probably in your own legal systems in Pakistan, to see whether you can find these elements in your laws as a way to think forward, and probably I hope this is not too science fiction, to think forward on automating certain claims in the judicial system, or at least probably integrating them in some ADR mechanism. And I choose the example of the airlines, and I explain you very briefly why, and with this I will finish my intervention. So if you can move to the next slide, please. The airlines, as I told you, there's a European regulation that establishes compensation for delay, denied boarding, etc. of flights, something that we stopped to be used to in the last couple of years, and now hopefully we can start to be used again. And this legislation has two characteristics. On the one hand, the breach of the contract is very binary, okay? So it's a calculation of time and distance. For example, a flight, you have a right to compensation if the flight is delayed more than 3 hours, and based on the distance, you receive X amount of compensation, etc., etc. This is very easily determined automatically. So these companies, what they're doing is they are connected to flight data that is offered by the airports, and very clearly and very easily, without intervention of humans, they are determining whether there was a flight delayed or not. And in Spain, for example, the authorities of the airports is trying to establish an ADR mechanism precisely to avoid the overflow of cases in courts based moving to some type of automation. And second, in the next slide, please, there is another characteristic is that the compensation is standardized. This regulation has 3 types of compensation, 250, 400, or 600 euros, depending on the distance of the flight. I know that this is very uncommon in many laws. I'm a contract lawyer. In contract law, especially, it's very uncommon. But precisely probably because of this not being common, it has fostered this legislation to be better, to be automated. Why? because once again, I'm thinking of any process of automation, if you have standard rules that can be generalized, it's easier to automate, it's easier to predict as well. So this legislation, what it shows us is certain characteristics of how the law is drafted that give us certain indications of its aptitude for automation in different contexts. So next slide, please. And with this, I finish. I wanted to thank you for your time, giving you some indications of experiments that we are still doing. So I'm very happy to receive comments from different means. Once again, from a lawyer's perspective, what this creates the risk, once again, is that our profession is being taken over by companies without lawyers. This could affect the rights of the litigants. And from a court's perspective, is a way of starting thinking the next step after the process of digitalization that, as Judge Kwan said, has been fostered by the pandemics. I regret not being there. I thank you very much for the invitation and for your patience. Thank you.
Thank you, Dr. Francisco, for having sparing your time, precious time, to attend the meeting, this conference. And I'm also thankful for your thought-provoking and compact speech. Naturally, we will be benefited from your experience and your expertise. Once again, thank you very much.
Thank you, Mr. Elizalde. Next, we have Mr. Jeffrey Apperson, who will be speaking on global best practices for case management and tackling the backlog. Mr. Apperson is currently the Vice President for the International Relations at the National Center for State Courts, an organization that has the mission to improve judicial administration in the courts of the United States and courts throughout the world. Mr. Apperson.
Thank you very much. It's an honor to be with all of you. And Mr. Chief Justice of Pakistan, and Chief Justices, Justices and Judges, former Justices and Chief Justices, ministers, lawyers, and distinguished guests, I'm honored to have received an invitation to speak on this panel with many of our best international experts, a reflection on the great effort by the conference organizers. And it's hard to follow these speeches, but I did want to say that this is my third conference in attending the Law and Justice Commission. And at the last, I will always remember the Supreme Court theme song on equal justice under law written by former Chief Justice Gilani. And if anyone hasn't heard it, it's a true inspiration. I began my career 40 years ago working as a court management review officer of the federal courts created by Chief Justice Warren Burger. And I will most likely end my career at the National Center for State Courts, another institution, Chief Justice Burger, that tries to serve the interests of the state courts and harmonious development based on best practice. I did want to note that as we talked about, as I listened to this, all the justices and Chief Justice yesterday, I noticed, I'm speaking in the United States, and I noticed the sun is rising. And after listening to speeches, I was thinking that the sun is also rising in Pakistan. And I wanted to note also after listening to the speeches that we all are serving one common component of our courts, and that is jurisdiction. And jurisdiction is only as strong as the sum of its parts. And there are many parts to administering jurisdiction effectively, one of which I believe is utilizing modern techniques and trends in managing our courts more effectively. And it's very obvious to me, I just returned from Mongolia, where much of their agenda was based on similar themes of this conference, that backlogs and delay are one of the greatest international challenges to the legitimacy of justice institutions. This issue cannot be understated. Also, and I noted from having been in the courts of Pakistan myself, the heavy workload of courts internationally is an equal issue. And I also know that for us to be successful as a jurisdiction, all parts must work together to accomplish the mission and goals of that jurisdiction. And I want to talk a little bit about my experience. And I won't need the slideshow now. I want to keep my comment generally summarized. After listening to the speakers, some of my slides that I think are most relevant to the topic of our discussion, particularly in the area we've been talking about, the virtual approaches, the new virtual approaches resulting from the pandemic that we've established and that we've been establishing over time. I do know this, and I heard Lahore yesterday, Islamabad, and we're talking about the development of case management systems. And those information management systems, and I've been, by the way, over my 40 years, I've been involved in several transitions from paper to electronic records. And I want to talk to you a little bit about my experiences in that regard. But I did want to say this, during the pandemic, the back here doubled, I would say. Even when the filings were going down, the backlog doubled. And we were trying to implement the virtual approaches to resolution of disputes. We were also trying to reinforce opportunities for mediation and arbitration. However, I did notice as I traveled that there were some common challenges in transitioning from manual to electronic practice. And I thought one of the main challenges was that many court officials had to work at home and they wanted to have hearings virtually, but they didn't have the record. It's hard to resolve disputes without the record. And I think that record access issue continues to be a practical issue in utilizing virtual techniques. I did want to say that we're always striving to define high-performance courts. And I know the National Center for State Courts has been trying to do this for years. But we always, and I noticed as the justices were talking about strategic planning, we all have a focusing on administrative excellence, continually seeking to sustain operational improvement, use court performance measures to manage and successfully leverage aspects of the court culture and conduct ongoing assessments of court practices. Technology is a means to achieve this goal. However, we need resources. And as I heard about having 4,100 judges for the millions of people in Pakistan that you have, I realized that doing more with less is even more important. To dispose of the court's caseload within established time standards, we must have sufficient judicial officers, admin, and court staff, facilities, equipment, and technology to schedule, hear, monitor, and dispose of cases. And I think that we also need to consider, in conjunction with the implementation of technology, that we need to modernize our budgetary and civil service practices to achieve our goals. Technology can contribute to productivity depending on whether it is sustainable and parallel paper operations are not in perpetuity. The goal should be to authenticate the electronic record as the original as quickly as possible. Professional management capacity necessary to maintain and develop systems must be strengthened in areas like of technical capacity, budgetary, and human resource areas. Also, education institutions must have modern systems engineering and programming curriculum designs. Also, necessary technology design capacity. Will there be national electronic data standards? Paper is a uniform format that facilitates uniform practice. Uniform electronic practice goals be considered. Work capacity is key to operational sustainability and effectiveness. Cybersecurity protection and strong internal controls for users is also important. The new system must enhance the user's ability to perform their job, to perform the job of judges, lawyers, staff, and the public. So these are just some of the common elements that I wanted to introduce. And I think creating a system, a modern system. But I also noticed as we were talking, as I heard the speeches, that I think development, and we had a problem in the United States where development at the state level was different. And while at the federal court, it was largely harmonious. And when you look at the operating systems, the cloud-based approaches to resource utilization, the programming languages involved in administering case management systems and electronic services, I believe that from lessons learned in the United States, it would be very important for the states of any country to co-develop to the greatest degree possible. In the United States, there was a report just generated by the General Accounting Office that reviewed the experience of the federal courts in implementing technology. And they established a view that there should be collaborative development opportunities based on open source opportunities so that source codes did not deviate from state to state. That would also improve the effectiveness of the appellate process and the Supreme Court appellate process. I think that report by GAO would be an important one for any country to study. I know as of now, we are implementing a new design in Argentina where they are also a federal system, and they are establishing a co-development approach to managing case management systems harmoniously and effectively at the national and the local level. So these are just a few of the topics that I wanted to bring to your attention without all of my slides. I also wanted to note that in the area of case management, Your Honor, there's a very important issue, and that is 40% of the cases in the United States are resolved before mediation. And those are process-driven considerations. Mediation is probably 50% of our case disposition methodology. Trials is 2%. And I did want to note, as you were talking about ADR, that it's important to link ADR to firm trial dates. And I've learned that the longer the case can go on, the more it benefits one party. So there's an interest to a degree in extending the process by one party. The firm trial date neutralizes that interest, and it also drives the incentive for much of the mediation process. That's just one of my things. The other thing I wanted to note is case management systems are critical in monitoring process, in basically establishing deadlines, monitoring deadlines, and executing on deadlines. So I think that area of inventory management in particular and the status of cases is a very important function of the case management system. So these are just a few, Your Honor, of my lessons learned, and I'm ready to finish at this point. So thank you, Your Honor. Appreciate it.
Thank you, Mr. Jeffrey. Of course, your 30 years experience will benefit us, and you have delivered a speech. This will help the stakeholders towards the digitalization of our institution, and especially the case management, which concern with us. So thank you once again.
Thank you, Mr. Apperson. Next, we have Mr. Mohammad Jafar. He will be speaking on the cyber crimes in Pakistan, challenges and the way forward. Mr. Mohammad Jafar is an officer of Police Service of Pakistan and belongs to the 26th Common of Central Superior Services. Mr. Jafar.
Thank you very much. Honorable Lordship, members of the bar, ladies and gentlemen, thank you very much. I'll be speaking on cyber crimes in Pakistan, challenges and way forward. Over the past 2 decades, crime has been increasing, making its way into the world of information technology. And as we all know, that internet crimes have become a normal now, and we frequently hear of different types of online incidents like credit and debit cards, theft on internet, which has become a well-recognized danger, as well as privacy and data security, which are significant topics in the modern technologically advanced economy. The most common forms of computer crimes reported to Cybercrime Wing, FIA, that we encounter are child exploitation, electronic fraud, electronic forgery, identity thefts, modesty and dignity of natural persons affected, hate speech, and sometimes cyber terrorism. The majority of the countries in our region are moving towards high tele-density, and the internet users are growing at a rapid pace. The figures I have, some figures that I'll quote. Pakistan's tele-density stands at around 88.21%, with 195 million cellular subscribers, 120 million 3G, 4G users, and 123 million broadband users. This increasing number of internet users in itself is a growing hazard in the light of cyber crimes and cyber attacks risks posed. Now, this is a global phenomenon, hence Pakistan is no exception. This enormous growth results in a greater number of incidents with every passing day. Hence, the number of expected complaints also increase with this ever-expanding pool of cyber users. This trend is confirmed from the increasing number of complaints we received at Cybercrime Wing. Last year alone, we had more than 100,000 complaints, and this year it has already crossed 85,000. Pakistan is undertaking new initiatives to achieve an all-inclusive national cyber security framework. We have PICA, Pakistan Electronic Crime Act 2016, and we have National Cyber Security Policy 2021. But there is a need for comprehensive and acceptable social media rules, as is mandated by Section 37 of PICA 16. Increasing technological development and internet use presents a challenge for us because of the extremely large amounts of data, where it is difficult to distinguish specific users. And also because of its electronic nature, the evidence is at times destroyed or wasted, recovery of which is sometimes very difficult. Additionally, because of the transnational nature of crime, in most of the cases, the evidence is with another entity, which is in some other jurisdiction and provision of which needs interagency and cross-border cooperation. Encryption is another tool used by criminals to stop incriminating data from getting into the hands of law enforcement, while the use of cryptocurrencies and blockchains allows criminals to deal with the proceeds of crime with a relative level of anonymity. The lack of data required by law enforcement has a significant detrimental impact on their work, often resulting in investigations being delayed or even discontinued. The use of encryption cryptocurrencies, blockchains, and other technologies such as dark web, VPN, proxy, and cold cloud storage present challenges for law enforcement in establishing the physical location of perpetrators, criminal infrastructure, or electronic evidence. This again raises jurisdictional considerations and makes it difficult to determine the source of crime. Now, legal frameworks vary between different countries of the world, making effective cross-border investigations and prosecution of crime extremely complex. The main differences relate to as to which conduct is criminalized and how investigations may be conducted. The former has a great impact on the collection of electronic evidence and monitoring of criminal activities online, which are critical to any cybercrime investigation. The lack of a common legal framework throughout the world presents significant hurdle to international cooperation more generally. This is particularly problematic in case of large-scale cybercrime that span multiple continents. Due to rapidly advancing technology and increasing speed of accessing data, investigators are finding it hard to keep pace with the piling incidents. Conversely, investigators require authorization and warrants before starting any legal proceedings. Cybercriminals can easily hide their identity by masquerading as some other entity or by hiding their IP addresses using the above referred proxies. Digital crimes also include cases where the attackers first steal the identity of a person and then use it to commit the crime. Most of the digital evidence can easily be lost as it is in the form of volatile data, as logs, records, pulses, or signals. The volatile data needs special tools to identify, gather, handle, interpret, and present data. The lack of such tools are